Okay, I'll go ahead and call the meeting to order. Welcome everyone to the May 5th regular board meeting of the Arizona Board of Pharmacy. My name is Lori Walmsley and I'm the board chair. The time is 8:30 and I call this meeting to order. Dr. Gandhi, can you please take roll call and declaration of conflicts of interest for members?
Thank you, Madam Chair. Mr. Solari,
At your service.
Mr. Dang,
Present.
Mr. Minkus,
Here.
Mr. Leba,
Here.
Ms. Lahan,
Present.
Ms. Walmsley,
Here.
Mr. Tong,
Present.
Mr. Goodman,
Virtually present.
and Ms. Nair.
Here.
Okay, I'll do conflicts of interest. Mr. Solari,
Yes, for you, which is the Optum Infusion Service, case number 200409, and Dr. K has my form.
thank you. Mr. Dang,
I don't have any.
okay, Mr. Minkus,
None.
Mr. Leba,
I have submitted those. I have 7A 21-0106, 4P 21-0068, 4Q 21-0087, 4AD 20-0522, 9A, and 30B.
okay, Ms. Lahan,
My forms have been submitted as well. Under tab 4, I have 4L 210028, 4M 200436, 4N 200536, and under tab 9, I have 9C.
Ms. Walmsley,
I've also submitted mine in advance for the record, but I have items 4B, 4D, 4E, 4F, 4H, 4K, 4R, 4S, 4Y, 4Z, 4AA, 9B, 10B2, 10B9, 20A, 20B, and 25B.
okay, Mr. Tong,
I have none.
Mr. Goodman,
None, thank you.
Ms. Nair,
Or Q. It's 20-0480.
okay, Madam Chair, roll call. Everybody's present, got conflicts, and happy Cinco de Mayo, and hopefully we have a great meeting.
Thank you very much, Dr. Gandhi.
Thank you.
Next item on the agenda is approval of the board meeting minutes from the March 24th and 25th meeting. Any discussion, or do I have a motion to approve?
Motion to approve.
Second.
Thank you. I have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? All right. Moving on to the items on the consent agenda, tab 4. First up is complaints. There are a number of items that were pulled due to lack of quorum from the complaint committee, so I apologize in advance. This is going to be probably a little bit longer conversation than normal. But items that are going to be pulled for full board discussion based on the inability to act during the complaint committee are items 4B, 4D, 4E, 4F, 4H, 4K, 4Q, 4R, 4S, 4U, 4Y, 4Z, and 4AA. And just for the record, 4U, we did have a request from the complainant potentially to speak, so that's the reason why that was pulled. The rest were pulled due to lack of quorum or additional information being provided. Are there any other items that board members would wish to pull off of the consent agenda for the complaint from the complaint committee?
Madam Chair, this is Kevin Dang. May I please have the full board take a look at 4G, 4I, and 4O.
4G, 4I, and 4O?
Yes.
Okay. Any additional? All right. Let's go ahead and jump into discussion of the items that we've pulled off then. Ms. Snare, can you please take item 4B since I'm recused due to my employment?
I sure will. Okay, so 4B, we have a licensee that failed to report charges within 10 working days. Just to start off the discussion, it looks to me like it's what we've seen many times, the failure to report. My thought is that it was a $250 fine for failure to report. Does anybody have any other discussion about that?
I concur.
Okay, I'll go ahead and just make that my motion, if that's okay with everyone. I make a motion for a $250 fine of failure to report.
Second.
All those in favor?
Aye.
Aye.
Any opposed?
Would that include proceed to hearing if not accepted?
Yes, thank you.
And we do need a roll call because that's disciplinary.
Okay, we'll do that again, please.
Okay, Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Wams is recused, Mr. Tong,
Aye.
Mr. Goodman,
Aye.
and Ms. Nair.
Aye,
Okay, ayes have it.
and let's move to 4D. That's the next one, I
Thank
believe.
you. I'm also recused on this one.
Yeah. 4D, pharmacist in charge failed to notify the board of a loss of controlled substance due to employee pilferage on a DEA Form 106 within 10 days. Anybody have any questions, discussion for this?
I have a question.
Yeah.
Do we know that if this delay in reporting caused this tech to be hired at another pharmacy?
Not that I'm aware of.
Okay. So that lag didn't cause the individual to be hired. Okay.
Not that we know of, no.
To add to that,
How-
Mr. Leba, is our data is as accurate as people, if they use it, right? If they enter that information. So we don't know if that person was employed or not at that time.
Mhm.
How have we handled this in the past? I don't recall if we've made any decisions on the things that have come before us, or if they've kind of been put off due to other circumstances.
It has not been a consistent discussion around this topic. So we don't have a clear-cut direction on how we manage this.
You know, I'm kind of thinking a letter of concern to the permit holder. I don't know, just put that out there for discussion.
Here's my take on this. This is a federal law, and we all know all pharmacists and all pharmacy permittees should be aware of should know for the fact that anytime where there is diversion occurred, the 106 DA 106 form must be filled out. When that form is filled out, it had happened to me on a couple occasions, and it's not difficult to fill out that form. Complete that form, send it to DEA, and send it to the Board of Pharmacy. I don't think it's a difficult task at all. And a letter of concern is too light on this because it's a requirement from our board, and it's also federal law to report the loss of controlled substances. So I think perhaps some sort of disciplinary letter to the PIC, because it is the PIC's responsibility to inform the board when there's loss of controlled substances. In my opinion, as a PIC, you should know the basic requirements set forth by the board and the DEA.
It's not that they didn't do it, it was the timing, I believe. That's the question. Mr. Leba, do you have a comment?
They did 15 days after.
That was going to be the from the event to the termination, was there an investigation that delayed that reporting? That would be my question, if board staff knows that. I think a lot of people, this is one of those areas that needs clarification because of that 24-hour notice. People think that is sufficient, and then they begin that investigation. And those investigations sometimes can take up to 3 weeks by the time items are done in a pharmacy, and by the time people are interviewed, and by the time legal reviews, by the time they come to the table. So that would be my question. That was kind of where I was going in the beginning with, was this individual, because of this delay, employed somewhere else? Because that is always my worry right there. And then my other question would be, was that, and I don't recall, board staff, and I apologize, but was there a 24-hour notice? And then how long was the event from the termination?
So I believe on page 180 of your board book, it does go over that. So the loss was discovered on April 14th by the permit holder or PIC. They terminated the technician on April 22nd. They sent us a notice that there's a possible controlled substance loss on April 29th, but they didn't say that a technician was involved or anything to that effect. And then we were notified on June 4th of 2020 about the employee pilferage.
If I recall, this was one where the pharmacy manager did not know that they were supposed to send in the 106 to the board. Is that right? If you recollect that as well?
That's right. I think what this case shows more than anything is that we don't have anything specifically that addresses them notifying us right away about a technician possibly being involved. And while they still had to, because they still had to do an investigation.
So we have in Arizona law, we have the time to submit the loss, but we don't have if you terminate an employee when you notify board on that. Is that right?
Exactly.
Madam Chair, may I share my thoughts?
Yes, Mr. Solari.
I generally agree with Mr. Dang, Dr. Dang. There seems to be a pattern here where the PIC notifies corporate, does some things, and then things get stuck in corporate muck and they don't advance fast enough as the law would want, as the statute would want. And so I am generally in favor in this case of some kind of a disciplinary action like Dr. Dang suggested, but to the permit, not to the PIC, because it's kind of a corporate, to me, the flaw exists in the corporate system. Somebody in the corporate could tell the PIC, hey, by law, you should be reporting this. Maybe we should do this kind of stuff. And I have seen, I think we have another case pending in front of us where this starts to feel like a pattern with this organization. So I'm generally in favor of some kind of a disciplinary thing, but towards the permit, not towards the PIC.
Chair, this is Goodman. May I speak?
Yeah. Yes, please.
Yeah. I would lean towards any discipline going to the PIC. We have to have an individual who's responsible to, I understand holding companies responsible as well, but in the end, the responsibility lies with the individual.
Madam Chair.
Yes, Kevin.
Okay, so I agree with Mr. Gilman, mainly because I understand that in the corporate world, there's multiple steps that we employees have to follow through, but it's all driven by the PIC. For example, in my case, I have to push corporate every day, remind my manager, HR on a daily basis when these kind of things happen. We have to be proactive. So that's why I think by penalizing the corporate they're not going to do anything because they always have to follow their own procedures. But us as a PIC, it is our job to make sure the company is abide by the law set forth by DA and the Board of Pharmacy.
Madam Chair, can I just add something?
Yes, Mr. Solari.
It's hard for the PIC to report this stuff if the corporate investigation isn't done on a timely basis. And for lack of a better term, the blame isn't placed on the person, in this case, the technician who took this stuff. And so that's where I'm leaning towards trying to get the corporate to speed their investigation up and their procedures a little bit to allow to pick some facts so that the PIC can report them. That's why I thought the fine should go, or the discipline should go to the PIC. Thank you.
Chair, this is Goodman.
Yes, Mr. Goodman.
Do we have to have it exclusive? Can we find both parties?
They're both named in the complaint.
Then
So we
I'd support that. Let's hold both accountable, and find both parties. The PIC
Mr.
and the
Goodman,
corporate.
do you have a suggestion?
Oh, I'm going to let someone else who's more educated make the motion. I have a true suggestion.
Okay,
Could someone point me to the provision that would apply in this instance to the permit holder?
So while you're looking for that, so Elizabeth, just to confirm, the permit holder was 5 days late in reporting of the 10?
No, so our law only specifically says that the loss has to be reported to the board within 10 days on a DEA 106 and the person responsible is the pharmacist in charge.
And how long did that 106? I just want to make sure. I see the termination took, it was 22nd, April 22nd, they were termed, and then the pilferage was reported on June 4th. But then when within that time frame, that 10-day, how late were they? Do you recall?
So we did not receive the DEA 106 until we got the actual loss on June 4th, 2020. And that's when they reported the employee pilferage.
Thank you.
Ms. Galvin, is it AD on the?
What provision are you looking at, Ms. Nair? What statutory provision?
R4 23-1003 AB is in dog.
And I believe that actually is specifically addressing the full service wholesaler. And that is on the bottom of that same page, Jean, if that helps.
Madam Chair and Jean, Dr. K, Jennifer K from the Board of Pharmacy emailed me the other day, the Arizona State Board of Pharmacy News issued on April 2020. It says, pharmacists in charge and permit holders, as a reminder, per 21 Code of Federal Regulations 1301.76B, like boy, it is the responsibility of the registrant to report significant loss to the DEA office via the Form 106 within 1 business day. And the PIC is also required to report the loss of controlled substances within 10 days to the board office on DEA 106. So that form was also, to my knowledge, was publicized to everyone last year. And in addition to reporting to the DEA and the Board of Pharmacy, the PIC should also require to report the loss to the Arizona Department of Public Safety as well.
Okay, Ms. Galvin, is it appropriate that we include the permit holder, in your opinion?
If you give me 1 second, please.
Okay.
Dr. Gandhi, what is federal law on the reporting? The 10 days is our regulation. What is federal law?
It's notification, not a DEA 106, notification to the DEA within one business day. So just a company letterhead letter sent to them.
And that was done. We didn't know it involved employee pilferage and we didn't know what was involved, but that was done.
I think to answer Ms. Galvin's question is, I guess we could address 32-1901.01A26 as failure to control substances and assign that to the permit holder.
Yeah, and that was the only one I was thinking of. You don't have a requirement to
And there was
comply
no
with
time
federal
limit on
law.
that.
Pardon me?
There was no time limit on that one.
No time limit on what?
On the permit holder reporting it.
On
To the-
26.
Correct.
Did they timely notify the DEA within 1 day?
Yes.
Okay.
I think if the time frame is mute in our statutes, it's up to the board members to determine an appropriate amount of time that passes. Was this enough time?
You have to look as what is reasonable, in the profession, in the community, under the circumstances when there is an investigation. It's unless, we could go into executive session for legal advice, but it's difficult to hold them to a standard of time within which to report if that is a standard of time that is not communicated to the permittees.
And you're specifically talking to the termination of the employee, but not to the 106.
Or if it's unclear, the permittee's obligation to report the possible diversion or the loss due to employee theft. Coming up with the standard is something that the board would have to do, and it would have to be communicated to the licensees. It appears there just may be a gap in our statutes.
I think the hardest thing, Gene, is people are confused with the 24-hour notice, then people are conducting the investigation to be sure, and then putting in the paperwork. But so that was kind of my question, and I might be a little bit confused. That's a whole separate topic, in my opinion. Then if we're specifically looking at the 10 days to report, there may be, you may not know in that 10 days, and you would have to select something on that form because they've narrowed it down, whether it be theft, package size, or what it may be. But that the 10 days is what is the hang up on today's topic, correct?
I would agree.
And it's not as much the reporting of the terminated employee because that's not outlined. So I do think record keeping is what we have, records and record keeping for lack of reporting within 10 days.
Yeah, and I see it as a learning because one, we're still trying to, I guess, get out the word that it has to be done within a certain time frame because of the confusion, as you're mentioning, Mr. Leyva.
It would sound like I would hold the permit holder more responsible than the PIC, because it's getting the process of determining why the loss occurred is the 10-day gap.
All right, so Ms. Galvin, are we able to hold the permit holder responsible at this?
May I make a motion for executive session for legal advice?
Second.
All in favor?
Aye.
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 Okay, it looks like we are all back from executive session. And does anyone like to proceed with discussion? Have anything to add?
Ms. Mayor, Madam Chair?
Yes, please.
Looking at this, I do think we're outside of the 10-day notification. I do think there are many unanswered questions that do have downstream impact if we react to this without all of the questions that we have and have discussed answered. I would be in favor of the advisory letter sending the message to the permit and to the PIC. I do think the permit has a policy and procedure because I saw it in the reading. I do think the PIC knew about the policy and procedure because he mentioned it. Just in 35 years, I've not had to do this. I do apologize. So I do think that there's both involved. I don't think we can just say one is involved and one is at blame. But for me, until some of these are answered and clarified and clearly communicated to the public, I am in favor of the advisory letter. And I do feel that message would be received by the permit and by the PIC. And then we come
I
back to
agree.
this as we have outlined previously.
Yeah, I agree with that. I'd actually, would you like to make that a
I'll make that a motion.
motion? Okay, I'll second that. Does anybody have any other discussion before we vote? Okay. All those in favor?
Aye.
Aye. Any opposed? Okay, thank you. All right, we're going to move on to 4E. Lori Walmsley is recused, and I will proceed. A pharmacy allegedly allowed the transfer of controlled substance to occur more than once. I don't mind starting off the discussion and saying it does look like there was confusion, but overall this was addressed, it was caught, and my thought was to dismiss. Does anybody have any other discussion about this? Okay, hearing none. Mr. Minkus, did you have something?
No, if that was a motion, I was going to second it.
Okay, I'll make that my motion, is to dismiss. Okay, all those in favor?
Aye.
Aye.
Any
Aye.
opposed? Okay, then we will move on to 4F. During
I'm
the
also recused on this one, since it's related to the other complaint.
Okay, sorry, I meant to mention that. 4F is during the course of investigation. These obviously go together. It was discovered the receiving pharmacist also mishandled the transfer and a second complaint was opened. I feel the same way about this one. I would make a motion to dismiss.
Second.
Any discussion before we vote? Okay. All those in favor? Aye.
Aye.
Any opposed? Okay. And
Next item is 4G that Mr. Dang asked to pull. So this is a CMG DME supplier relocated and failed to provide 30 days notice to the Arizona Board of Pharmacy staff prior to the move. The recommendation of the committee was to offer consent agreement for a $1,000 civil penalty with standard terms if the licensee does not sign the consent or pay the penalty, move to formal hearing. Dr. Dang, you asked to have this pulled, so do you want to kind of state your concerns here?
You're muted.
You're muted.
Okay, sorry about that. The reason why I had asked the full board to take a closer look at this particular case is because based on my recollection, I don't remember us imposing any fine to DME supplier for similar type of action in the past. So I just want to make sure that as a board, we are consistent with what we have done in the past.
I agree. Staff, what I believe we've asked for the consistent amount is, and can you state here that it is consistent or not? I believe that we've discussed it.
Yeah, that was part of our discussion during the complaint committee.
Thank you. Then
Dr. K, can you weigh in there just for the edification of the full board?
Yes, from our understanding and our knowledge of what we've done, this has been standard. Relocating without telling the board is a serious issue.
Okay, so that fine applies to DME supplier as well as to retail pharmacies, right?
If they relocated, I know we've addressed it from a different perspective as well, from a pharmacy perspective, because they can ship products and it can result in shipping products into Arizona or selling products in Arizona from an unpermitted facility. So we have looked at it from that angle as well.
Thank you.
I think the one thing I would say is that every single time it doesn't have to be a fine. We can look at the cases individually and look at it. I know consistency is important. The whole picture in this one led me to believe that it was an appropriate recommendation because of other circumstances that we have seen as a board with this permit. And that's why I did support the recommendation of the committee in this case.
I agree. There were other extenuating circumstances with this particular case and some of the individuals that were involved that were discussed during committee. So Dr. Dang, does that resolve your concerns with this?
That's it, Madam Chair.
Since we've went ahead and pulled it, my motion will be to uphold the recommendation of the complaint committee for the $1,000 consent agreement for a civil penalty with the standard terms. If not paid, then move the formal hearing. Do I have a second?
Yes.
This is a roll call since it's discipline.
We can just take all the recommendations from the committee all at once at the end. So if you're upholding our recommendation, we'll just let it
Okay,
stand.
that's fine. I didn't know if we wanted to take it now since we pulled it out. We can do that since we'll stick with the other. Okay. Kristen, do you want to
Well,
go ahead and
You have a motion and a second on the table, so if you don't vote on it, then we'll need to have that withdrawn.
I'm willing to withdraw my motion.
Withdraw a second.
Withdraw a second.
All right, Kristen, can you take item 4H, please?
Okay. 4H is the wrong strength of testosterone was dispensed to a patient. So is there any discussion or questions? My thought was to offer CE to both the pharmacist and the technician. And it looks like the technician's already done that. So I would accept the CE that they've done.
So these CEs are in addition to their annual.
It would be in addition to, and it was going to be under error prevention. And it looks like the technician's done 6 hours already, but I was recommending 3.
This is Goodman.
Yeah.
So on the board, we talk a lot of precedent. So does that logic start to set the precedent that I should be able to assign my own penalties to my infractions?
No, and I understand what you're saying. I just think that they took it upon themselves, and I'm not going to hold that against them for being proactive.
Okay.
You know, taking it-
Yeah, it
Yeah, go
depends
ahead.
a lot on, is it aligned with what we would assign anyway? And that you would know that better, so.
It
I
is,
would
in
say
my
yes.
opinion, and,
Yeah.
and I do believe we've acted that way in the past. And what it shows me, more than anything, this is trying to correct a behavior and learn something out of it.
Mhm.
And the individual taking it upon themselves and coming beforehand saying, I'm upset that it happened. Here's what I've done to better myself. To me, that goes a long way in these cases. And that's why I do support Kristen's honoring the 3 CE if it is submitted and verified by board staff.
Okay, so I'll make an actual motion. 3 hours of CE for the technician and for the pharmacist. It's above what's required to be done within 90 days, to honor what's already been done by the technician. And if not signed, proceed to hearing.
Is this a non-disciplinary order?
Non-disciplinary.
So it wouldn't be a consent agreement. You're issuing a non-disciplinary
I was trying
CE.
to be thorough. Went a little beyond, sorry.
Are only requiring 3 hours. The technician completed 6. Is she allowed to have that 3 that she did take over and above what you are ordering apply to her renewal?
Yes, definitely.
And this is error prevention, correct?
Yes,
Madam Chair, this is Kevin.
yes.
So I do agree that 3 hours of errors prevention CE would be the appropriate approach. But since it's also involved controlled substances, should we consider 3 hours of error prevention and 3 hours of controlled substances?
I mean, my thought is just that that's not really that consistent with what we've done, but that's me. Does anybody have any other thoughts?
My question would be, Kevin, how do you think in this case it would have been different? There's where I struggle. Even though it is a controlled, it's testosterone, I don't think that there was malintent with controlled substances. It could have been lisinopril, in my opinion. It happened. That's why I think it's sufficient with just 3 CEs. And that's my opinion, Kevin. And I do hear what you're saying, but I look at it as if there was not malintent with a controlled substance. It's a mistake.
I agree. I think the reason why I brought up the 3 hours of controlled substances CE is because, in my opinion, by having these 2 individuals take CEs on controlled substances, aside from teaching them the importance of making sure that the errors related to controlled substances are not happening, but they also give them a chance to learn more about all other aspects about controlled substances, since our state and many other states are beginning to have more and more rules and regs pertaining to the usage of controlled substances or the dispensing of controlled substances to the public. So I guess the whole thing is more for their education. So what we can do is, rather than just narrowing down to errors prevention, can we say errors prevention or 3 hours of controlled substances?
Yeah, that sounds like a good compromise. Okay. I'd be willing to amend my motion to be 3 hours of CE for the pharmacist and the technician, either in controlled substance related topics, or unless you want to narrow that down,
no,
or
dispensing of controlled substances.
Okay, dispensing of controlled substances, or in error prevention.
I will not disagree with it. However, I don't think we can say that there's a problem with controlled substances dispensing. What we can say is that there was an error in filling, and that education on error prevention would go a long way. And that's why I think that better choice, in my opinion, would be error prevention is what happened in this case, versus assuming there's a problem with controlled substance dispensing. I don't see that here.
I agree, but I'm also willing to compromise and make that my motion. So I've amended my motion, but I don't have a second. Does anybody want a second?
Second.
Okay. And any other discussion before we vote?
Yes, I'd like to clarify something that was mentioned, if I may. If the review of the technician CE that has been completed does not involve error prevention or dispensing of controlled substances, and can we receive direction as far as next steps for that technician?
Yeah, I thought it was in error prevention. Is that, did she not specify?
Oh, when they specify and when they submit the documents can be different. So
yeah, it reads in prevention of errors, but so assuming that that's correct.
And then I think it's implied in the motion, if it's not correct, she still has to meet your requirements.
Yes.
Perfect.
Okay, so we're going to go ahead and vote. All those in favor? Aye.
Aye. Aye.
Aye.
Any opposed? Okay, thank you.
Okay, next up is item, pardon me, 4I. This item was asked to be pulled by Dr. Dang. This is a complainant alleged that the pharmacy incorrectly filled a prescription. The recommendation from the complaint committee is a non-disciplinary order for 3 hours of continuing education and error prevention within 90 days of the hours to be in addition to the hours for the original licensure. Dr. Dang, what is your concern with the recommendation here?
Madam Chair, I apologize. I want to revoke my request. So for 4I, I'm good. I'm good now. Thank you.
Okay. All right. So we'll move that to the full decision then.
Yes.
Next up is 4K. Can you take that one, Ms. Nair?
Sure. Yep. 4K is incorrect medication was filled and dispensed to a patient. So to me, one of the things that stood out was the counseling was not documented. Does anybody have?
Well, what stood out to me, Madam Chair, is the verifying RPH had a chance, the counseling RPH had a chance, and the tech filling had a chance. So I was in favor of 3CE non-disciplinary to all three involved that touch the prescription, in addition to do within 90 days.
I would second that if that's your motion.
I'll make that a motion.
Do you have a topic that you would like?
Error prevention. Thank you.
Second.
Is there any other discussion? Okay, then we'll go ahead and vote. All those in favor?
Aye.
Aye.
Any opposed?
Okay, next up is item 4O. This was pulled by Dr. Dang. A pharmacy failed to report to the CSPMP database. The recommended action from the complaint committee was an advisory letter. Dr. Dang.
Yes, Madam Chair. So in my opinion, from reading the narrative, advisory letter is too light of a discipline for this particular permit holder, just because our staff has already emailed the pharmacy 7 times, and it has also proven that the emails were open and read. So I don't think an advisory letter would be applicable here. We need to do something more stringent, like this is some sort of disciplinary action rather than just advisory letter.
So in our discussion, just for the benefit of the full board, we discussed in this particular situation, this is a little bit different than some of the other CSPMP issues that we've had in the past. This one, it wasn't that they were failing to report dispensings, they were failing to report 0 reports. So they were failing to report that nothing was dispensed on those days. So it wasn't like there would be potential action related to somebody receiving a controlled substance or something like that in duplication with others.
Yeah, and I don't see a public safety concern, really. I mean, yes, they should be doing what's required. And that's why a letter of concern would be appropriate, in my opinion.
I agree.
Any further discussion as a group? Do I have a suggestion on how to handle this? Do we want to hold the recommendation, or do we have an alternative motion?
Madam
Go ahead,
Chair,
Dr. Day.
so looking at the email that Samantha Luttrell sent out to the pharmacy on June 6, 2019. In the email, I think it is very clear to the pharmacy holder, the permit holder. It said daily reporting is required, including days you dispense 0 control medication. I mean, it is there. How can you miss that information? So in my opinion, the pharmacy permit holder here was just plain negligent of the direction that was sent out to the pharmacy permit holder. And for 7 times, someone had emailed out to the permit holder, and the permit holder just continued to ignore that. And here we are just giving them an advisory letter. That, to me, it's not going to set a good precedent for the future cases.
Dr. Deng, do you have an alternative motion that you'd like to propose for the group?
I would say, since we communicated to the pharmacy holder 7 times, we'll go with $1,000 fine, or we can go with $100 for each notification that was sent out to the pharmacy permit holder. That's just my thought.
Any additional discussion from other board members?
Madam Chair,
Yes.
looking at this, it's a out-of-state pharmacy. They were not dispensing. I think there was ample time for them to read the darn emails and say, oh, even though we're not dispensing, we need to report 0 days. I think there was a disconnect there. There's not a danger here. I understand what Dr. Deng is saying, but I still am not in favor of a fine for it. I am in favor of a advisory letter with specific Arizona law in controlled substances. And I do think that they would probably learn more having to actually do some CE on controlled substances versus paying a fine. If we saw over and over that the individual was dispensing controlled substances, not reporting, I would feel different. But I do think that it's odd that you have to report in 0 days too, and it could be a little bit confusing. And Kevin, you're right. They could have read those emails. They admit in their letter that they didn't, and they should have. And going forward, they will, and they fixed it.
And that's the benefit to me of the advisory letter. If they don't fix it, then there's something on record that says we've already warned you on this, so then we could take a stiffer penalty. But I personally stand by the complaint committee's original recommendation. I don't think that there's a danger to the public. I think it was an administrative error, and it's important, but there wasn't patient harm because of it. And there could not have been patient harm from a 0 report.
I agree.
But I still think that for us, for our board staff to having to send out 7 emails, that is just insane. And it's a waste of our staff productive time. And so I am still in favor of some sort of discipline rather than just advisory letter.
So I have this, Dr. Deng had a motion of a consent agreement for a $1,000 fine. Is there anybody that wishes to second that motion? Hearing none, do I have an alternative suggestion?
Madam Chair, I think Dr. Deng brings up a good point, and that's why I'm in favor of assigning Arizona law and controlled substances to the pharmacy, 3 hours non-disciplinary on top of the advisory letter. I think there's learning there on Arizona law that they may not have.
Who would you have the CE go to? The CE can't be completed by the pharmacy.
The pharmacist in charge. Pharmacist in charge is ultimately responsible for the reporting.
It doesn't look like they're listed in the complaint. Looks like it's just a permit holder.
That's correct. We do not license the PIC of that pharmacy.
Madam Chair, I think we're trying to find something to send a pretty strong message that you need to do this and this is part of our rules. But I think an advisory letter will be more than sufficient and get their attention. I think that would take care of it. And I'd suggest that we just go with the committee's recommendation of that and leave it at that. And then we can vote on all of them at the end. That would be my opinion. Thank you.
Thank you, Mr. Minkus. Any additional thoughts or comments on this?
Do you need a vote? Do you need a motion, Madam Chair?
Not if we intend to accept the committee's original. Correct, Mr. Hargraves? Or should we take a motion in this case since there's some conflict here?
Well, because there's been somewhat of a disagreement, it may be best to take it separately. So that way any objections can be noted for the record.
Okay. So let's, Mr. Minkus, is that your motion then?
Yes, to leave it as it is from the committee recommendation.
I'll second.
Goodman, second. Oh,
Okay, thank you. Any additional discussion? All those in favor?
Aye.
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 Any opposed?
Nay.
Thank you.
For the record,
Um,
Mr. Dang was the nay for the record.
Thank you. Next up is item 4Q. This
I'm
is,
recused. I just want to.
yes, thank you. A prescriber's office alleged that a pharmacy is sending fax prescription requests for patients that are not patients of the pharmacy and without requests of the patient. Again, this item was not discussed at the committee level due to lack of quorum. Board members.
Madam
Thoughts
Chair,
or
I will
discussion?
recuse as well.
Okay, thank you.
Madam Chair, may I share my thoughts?
Yes, please.
This pharmacy, of course, is in front of us for other infractions which are pending, but they suggested that they have audio of the patient requesting that the prescription be sent to them, and they were going to provide us the audio. Board staff, has the audio been provided as they claim they have?
It has.
Ms. Richardson, you can corroborate that the patient, there's audio evidence that the patient requested the prescription to be filled by these, or to be transferred to this pharmacy?
What the audio says is there is a customer service agent saying that they were going to have their omega-3 sent to them, and the patient's response asks if it is One Touch. And the agent says, yes, that'll be for your diabetic supplies, but this is just for your omega-3. The patient says, okay. So it sounded like a little bit of confusion in the audio recording, but that is the gist of what they said.
I guess at this point, since we don't have, we have this audio and the patient is confused or not, but admitting that they do want the prescription transferred, I think we can dismiss this, but then address the pharmacy issues when this pharmacy comes back in front of us again. So I'm not sure that there's enough evidence to do anything to this pharmacy disciplinary wise. So I'm recommending dismissal at this point because of the audio.
To me, the one thing that is still a bit of a question here, and this is something from the other case, is whether or not an unlicensed entity is performing duties that a licensed person should perform. And the information that is here is not super clear to me, but I think that can still be addressed in the other complaint that is still pending. But I believe I kind of tend to agree with you too, Dr. Solari, that it's a little bit of a he said, she said situation here. There is the chance that the patient is confused. I don't know if there's enough true evidence to take any action here on this particular one. Any additional thoughts or questions from other board members? Dr. Solari, are you ready to make a motion on this one?
Yeah, I'll make a motion to dismiss this complaint at this point due to lack of evidence.
Second.
Any further? I have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Noting the recusals. Next up, item 4R. Ms. Snare, can you take this item due to my recusal, please?
Yes. 4R, a complainant indicated the pharmacy roof was leaking and black mold was growing in the ceiling. So there's been no proof that there's any mold in the ceiling, and this has been repaired. So my recommendation would be to dismiss.
Second.
Any discussion? Okay, all those in favor? Aye.
Aye.
Any opposed? Okay, move on to 4S. Ms.
Thank you.
Walmsley is recused. Patient alleged that the pharmacist refused to refill his testosterone 10 milligram vial earlier than the 76-day calculated days supply. So my thought on this is that the patient did get the correct dose and they got the correct medication. It was more of a customer service issue. And my thought was that we dismiss.
Second.
Okay, any discussion? Okay, all those in favor? Aye.
Aye.
Any opposed?
Next up is item 4U. Dr. Gandhi is the individual that asked to appear to address the board on the line or in the room.
Yes,
Madam
I
Chair?
believe I did see Ms. DeLeon. I'm sorry, the person.
And I'm recusing.
Thank you. Board members, item 4U is a complaint of unsafe compounding practices. For background, this item was an item that was dismissed by the executive director at our prior meeting for no violations found as a result of the inspector's compliance visit in relation to the complaint. The complaint committee discussed this, and the individual that is present was available for questions or to make a statement if that was the case. The recommendation of the complaint committee is to uphold the executive director's recommendation and to dismiss the complaint. Board members, any discussion, or do we wish to hear from the individual that's on the line at this point?
Madam Chair.
Does the respondent wish to make any comments, brief comments?
Would that be
Or the
me?
complainant? Yes, the complainant. I'm sorry, not the respondent.
Yeah, I would like to say a couple of things. I'm not sure exactly how it was sent over to the investigator, the pharmacist investigator, but I just want to share my story with the board because I think that what's happening at United Healthcare Group and with all corporations with the pharmacy is something that we can't really get around. I know a few individuals touched on it briefly, the corporate culture. Well, I was hired into UHG about 2 years ago. I had zero experience as a sterile compounder, like absolutely none. I didn't even go to one of the accrediting schools. So I was grandfathered into being a technician. I was in my last year with ASU, set to take the PCAT, everything. And UHG decided to hire me on as a sterile compounder. During that time, I was promised training because they knew I had no experience. I was promised training from the pharmacy director, Deborah Melita, from the supervisor of pharmacy technicians, Kristen Elsesser, and he's not necessarily a pick, but he's the pharmacist that runs everything, Peter Callender. I was hired on and I was never provided that training, ever. They never assessed me. They never, I think they did take my fingerprints, but they didn't even do it. Another employee, a peer of mine, did it. So I don't know about the incubation period, whatnot. And that was just.
And let me just stop you here just briefly. Just for your purposes, we have a lot of materials that we're going to need to cover today, a lot of agenda items. Everything that you've provided to the board has in writing, the board members have read and reviewed. So if you could try and keep your comments just to the brief high level facts so that we can keep our meeting moving along. Thank you.
Oh, so, okay. So I think I've stressed the point that I was never provided any of that training. So I have literally folders here that I'm going through with different agencies with federal violations that were broken with that pharmacy and state statutes. So when I requested to have this reviewed, how it was dismissed, I couldn't understand the what basis, how it was dismissed, because I know what happened at the pharmacy. I saw it with my eyes for a full year. I'm with talking with OCI now, with FDA. I wouldn't just throw away my future like that just off of a hunch. I have collected everything that I needed to. And so when I asked for this review, I'm really asking what the pharmacy, the Board of Pharmacy, what they're doing to protect the public.
Board members, any questions for this individual?
I think it's fair to note that there's two sides to every story, and we have received information from more than just yourself. So in balancing the information that we've received, I would stay with the recommendation of the board staff.
Second.
To be clear, that's your motion, I believe it was, is to uphold the executive director dismissal.
Yeah, I hadn't officially made it a motion, but yes, I can make that my motion. Yes.
Well, I'm just trying to be clear for the record. Whatever
Yeah,
motion.
I was just discussing it, but that's fine. I can make that my motion to uphold board staff's dismissal on this case.
Second.
In the basis for the dismissal, just for the record, Ms. Nair.
The information doesn't have any factual, or it's a he said, she said. We don't have the evidence to uphold anything.
I think, Ms. Nair, I think we also, the board did send an inspector out there to validate the allegations, and we couldn't prove those allegations.
Thank you, Dr. Gandhi. So I have a motion and a second. Any further discussion from board members? All those in favor?
Aye.
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 Any opposed? Thank you. Appreciate your attendance today.
Thank you.
Next up, item 4Y. Ms. Snare, can you take that one, please?
Yes. A pharmacy technician worked on an expired license. This is also attached to 20A. Want to make that known. I believe it was 562 hours on an expired license. I don't know how many days that is. Hold on, I can do some quick math here.
That's like 4 months worth of 4 months out of a year.
70 days.
Madam Chair, did you want to pull 4Y, and then when we get to 20A, you can address them together?
Sure, that'd be fine. Then what's next?
4Z.
4Z. Okay, we'll move to 4Z. It is patient alleged that the pharmacist did not want to counsel her or her prescriptions, and that the pharmacy does not have a complete allergy record on her profile. Any ideas on this one? It looks like they did try to follow up. They did call and they did update the allergies. Does anybody have any thoughts on that?
In reviewing and reading it, I just didn't see merit to the complaint. In my notes, I have dismiss.
So do I. Do you want to make a motion, Mr. Leyba?
So moved.
Second. Any other discussion? All those in favor? Aye.
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 Any opposed? Thank you.
4AA.
4AA, pharmacy technician worked on expired license. This is also with 20B. So did you want to wait on that one as well?
It might be best, Madam Chair.
Okay, we'll pull that one until we go to 20B.
that takes us to the end of the ones that were pulled. Do I have a motion for the rest of the items that remained on the consent agenda?
There's item 4AB, Madam Chair.
I didn't think we pulled that one.
That's a full board review.
Oh, I apologize. I missed that one. Item 4AB, thank you for directing me there. This one, the licensee disclosed disciplinary action by a professional board in another state. This item, where is it at here? We recommended that the full board discuss it. I believe we have the attorney for the individual on the line if we'd like to hear from them.
So my first thought on this is there's already a pop-up. He's entered into pop-up, but it's not under our direction, so it wouldn't be in our purview. So that would be something I would want to address, that we would have the reporting and insight to that, if that's what we're going to do.
Isn't this the one that we got the letter from last night from you, Jennifer?
Yes.
Yeah.
Okay. So he has signed a PAPA contract, or will sign.
Do we need to go into executive session?
Yes.
Yeah, there's a lot of private health information here. It's probably best if we do that. I'll make that my motion to move into to executive session for the purposes of discussing confidential information.
Second.
Okay,
All those in favor?
Aye.
Aye.
Aye. Ms. Galvin, did you have a
just so
comment?
Crystal knows to bring the attorney and the licensee.
Thank you. Board members, additional questions for Mr. Bozen unrelated to HIPAA information or a discussion?
Mr. Bozen, would your client be available to appear in front of us later today or tomorrow?
I can ask. I'm assuming that he will make the time. Happy to try to accommodate that.
Madam Chair, may I withdraw my previous motion for conference at this point and then request that we table this matter until Mr. Bozen gets back to us with information whether his client is would be willing to appear in front of us, and if so, continue this at that point.
Do I have an amended second?
Second.
Which would be up to tomorrow, right, Mr. Solari?
Yeah, whenever. If his client can appear later today, great. If it's tomorrow, then tomorrow.
Perfect.
Yeah.
But if he's not able to appear by end of day tomorrow, then we'll need to determine at that point how best to move forward with this if he's unable to appear.
When Mr. Bozen gets back to us with a yay or a nay, then we'll make a decision at that point how to proceed.
Okay. Who had the original second for the?
Dr. Tong.
Okay, so you're willing to amend, Dr. Tong? Is that a yes?
Yes.
Okay. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Thank you, Mr. Bozen. Appreciate it. And we look forward to hearing from you about your client's availability later today or tomorrow.
My pleasure.
Madam Chair, if I may.
Yes.
I know there was also discussion from the complainant on 4AD. If you guys can maybe review that. Question on the executive director dismissal. It was brought to my attention by one of our compliance officers that was challenged by the person that filed the complaint.
Did we not already vote on the consent agenda?
We did not.
Not as a whole, no.
Okay, all right, thanks. Sorry.
I don't know that I think a discussion on it is necessary. The complaint committee reviewed the information, and unless other board members have further discussion, there's no violations listed, so I am still of the opinion that dismiss is appropriate.
Okay, my intent was just to shed light on it, that we readdressed it and sort of discussed it.
Board members, any additional thoughts or concerns on item 4AD?
She did make an effort to appear at the meeting today.
She did?
Yeah. The complainant is here.
Do we wish to,
This is a recusal for me, just, you know.
do we wish to hear from the complainant? Board members?
Yes, I think we should.
Sure. We allow the other one to.
Yes.
Dr. Gandhi, is this individual on the line or in the room?
I am looking for a Madam Chair. Was
Dr. Gandhi, if you know the
Madam Chair,
individual's
I
name,
do
if you
not.
want to call them.
Yeah, I do not see them on the line.
Okay. Board
So-
members, any additional discussion on this topic? Do we want to wait and see if they come back or go ahead and address this at this point in time?
Ms. Calvin, are you referring to the other person that filed the,
No.
or, okay.
I don't think the board is under any requirement to wait to see if the person rejoins. I would go ahead and,
Okay. My recommendation would be to uphold the dismissal, the recommendation for dismissal.
Agreed.
Yeah.
Leave it on the consent agenda.
Yes.
Okay. Dr. Gandhi, any other items remaining before we vote on the consent agenda for the complaints?
No, I think we got it all, Madam Chair.
Okay. Thank goodness. Do I have a motion to address the consent agenda for the complaints?
Madam Chair, I'm willing to make the motion to approve the consent agenda with the recommendations of the complaint committee.
Thank you, Mr. Solari. Do I have a second?
Second.
I have a motion and a second. Any further discussion?
Madam Chair, that would be roll call. We may have some discipline entangled in there.
Okay.
And just to be clear, that excludes the two items that you pulled to be handled separately with, I believe, agenda item 20.
Yes, there were two that were, yes.
Yep.
What were those two item numbers? I'm sorry, just make sure I have it on my notes.
It was 4Y.
And
4Y.
4AA.
Okay,
and
perfect. Thank you.
4AA. Yep.
So noting the pulling of those to address later in the meeting.
If it's
I have
okay, I'll
a-
take a roll call, Madam Chair.
Yep, go ahead.
Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Wamsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman is not present, and Ms. Snare.
Aye.
And then noting all the recusals and so forth. Thank you.
Thank you. Board members, we've been at it for almost 2 hours, so let's take a brief recess for a break, 10 minutes or 15 minutes.
It's good.
10, Madam Chair.
All right, 10. So we'll come back at 10:40. There. Welcome back from break. Apologize, I had to sign off and jump back on. Dr. Gandhi, were you able to interject with Mr. McClellan?
Yes, I was, Madam Chair. So he will be returning. We have several agenda items before his. He'll come back after 1 o'clock.
Thank you.
So
All right.
it is under conferences.
All right, I appreciate it. Thank you. Again, apologize for the issues with my computer connectivity there. Let's jump back into the agenda. Item 5 is vacant. Item 6 are the executive director's dismissals. Do I have any discussion or a motion for that item? Or can we take all of these together, all of the rest of the consent agenda?
You can take them all together if you'd like, Madam Chair.
Board members, do we have any items that we wish to pull off of those consent agenda items, or do we wish to take items 5, 6, 7, 8, 9, and 10 together?
And 11 is vacant, so.
Yeah, and 11.
I think we can take them together.
All right, do I have a motion?
I'll make a motion to approve.
Second is Kevin.
Any discussion? All those in favor?
You do need a roll call.
And,
Okay.
and noting recusals.
Yes.
You know what, I'm recused on 9A. Maybe I should make the motion, Ms. Galvin, your call.
That's correct. You should not.
Okay, I withdraw.
So do I have a motion?
I'll make a motion to approve item tabs 5 through 10,
Second.
Noting recusals.
noting recusals.
Okay, I have a motion and a second. Dr. Gandhi, can you do a roll call?
Certainly. Mr. Solari,
Aye.
Mr. Dang,
Aye.
Mr. Minkus,
Aye.
Mr. Leba,
Aye.
Ms. Lehan,
Aye.
Ms. Walmsley,
Aye.
Mr. Tong,
Aye.
Mr. Goodman, are you back? Not present. And Ms. Nair.
Aye.
Ayes have it, noting recusals.
Thank you, Dr. Gandhi. Tab number 11 is vacant. Tab 12, resident pharmacy permit applications requiring board approval. Item 12A is for Meta Pharmacy. Dr. Gandhi, correct me if I'm wrong, but we received a request late in the evening yesterday to continue this matter to the next meeting due to the pending pro hoc vice from the individuals council.
Correct, as well as a scheduling conflict. I believe she had another matter in the courts. So it's item 12A, Meta Pharmacy, as well as 25C involving
Correct.
Glendale Pharmacy are both requested for postponement to the next meeting.
Madam Chair, may I ask a question for legal counsel?
Yes, go ahead.
How many times, is there a limit on how many times somebody can postpone or ask for continuation? This matter has been in front of us, it seems like a year. What are the rules on continuation? Could you enlighten us?
There is no limit as far as the number of times that a matter can be continued. That would be within the board's discretion. This is concerning because of the length of time that it has been before the board, but as Ms. Walmsley suggested late yesterday, we were notified that the attorney had an appearance in a court, I believe it was a superior court, and that does take precedent over an administrative body. And so there was really little choice but to grant her request for continuance.
Mr. Solari, board staff had the same concern. We did contact Ms. Galvin regarding this matter. It had to be a pretty solid reason for board to consider accepting their request.
Thank you, Dr. Gandhi.
All right, so item 12A will be continued to the July meeting. Moving on to tab 13, non-resident pharmacy permits requiring board review. Item 13A is Allergy Partners Therapeutics. Is somebody present from Allergy Partners? All right. I believe Mr. Hyber was the compliance officer on this, but Allergy Partners disclosed a list of a number of member owners, of which many are physician medical practitioners who would receive compensation either directly or indirectly from the pharmacy. Board members, any discussion on this item?
Should we move forward without anyone being here?
I don't know how we can. We have to have the question answered.
Yeah.
Kind of my opinion.
Yeah. So
We could reach out to him at lunchtime, Madam Chair.
Okay, so come back to this one.
Yeah, we'll make an attempt.
Okay. I'm not comfortable moving forward unless we speak with them. All right, item 13B, option 1 infusion. This is option 1 infusion had several prescription order blank forms on letterheads listed as referral forms on their website. Ms. Richardson was the compliance officer. Ms. Richardson, do you want to give a brief summary of your concerns?
Yes, Ms. Walmsley. So as you stated, they do have prescription referral forms on their website, which advertise the pharmacy information, which is prohibited through Arizona statute. I do believe we received an attestation from them that they would not use those. I don't know how that will be enforced, however. In addition to the prescription blanks on their website, there was also concern about discipline. There were 8 disciplinary orders, 6 of which were within the last 5 years at various locations. The most concerning one was in 2017 for their Oklahoma location that had some serious sterile compounding violations. And I believe that information should be included in the packet.
Thank you, Ms. Richardson. Do we have anybody present from option 1 infusion?
We do, Madam Chair. Mr. Reese is on, I believe.
Mr. Reese, can you please state your name and position for the record?
My name is Chad Reese. I'm the Pharmacy Operations Manager at Option 1 Infusion in Oklahoma City.
Thank you, Mr. Reese. Board members, questions for Ms. Richardson or Mr. Reese?
I'd like to point out, first of all, this is a change in ownership application for us. We were previously licensed in Arizona as Option 1 LLC. We were recently purchased by Emerita, which is a corporate chain, and we are a separate branch from the Tulsa branch, which is also in Oklahoma, that Mrs. Richardson alluded to. So we've never had any issues with Arizona in the past. The discipline is with other Emerita branches. We have just recently come on board as part of their corporation on December 1st.
Thank you, Mr. Reese. Appreciate that. So in relation to Ms. Richardson's concern about the prescription blank that's posted on your website, understanding that you did submit an attestation that you would not be using that for Arizona, how do you plan to enforce and ensure that that would not occur with prescriptions that are dispensed for our state?
As I mentioned, we being previously licensed, we just do not accept these from Arizona prescribers. We are licensed in, I believe, we're working on a couple of licenses, this one included, about 33 other states. And so we do have close working relationships with physicians here in Oklahoma and other states that utilize those, but we simply don't use them with any Arizona prescribers.
Madam Chair, may I make a comment for the interest of patient safety?
Yes, please.
In the hospital, we use some of these drugs, and they're very complicated products. I realize that these are prescription blanks or referral forms, and they're technically illegal. But there's a lot of good information on this that physicians, when they prescribe, neglect to order pre-medications, medications for treating side effects if there is some during the infusions. I like these forms. Hospitals routinely use these forms. I want to find a way to not use them as referral forms, but then when it comes time to prescribing the drugs or these infusions, have these available to physicians so they don't neglect to order pre-meds or drugs that are used to treat the side effects of these agents. These are, complicated drugs. They're not simple things to prescribe. I just want to throw that out for board consideration.
Yeah, and perhaps that's something that we could address during the rule rewrite discussions that we plan to have.
Ms. Walmsley, this is Sharon. If I
Go ahead.
may, the form in and of itself would be fine to use if they did not put their pharmacy information on it. So providing it on their website is not a problem. It's the fact that it advertises the pharmacy with their fax number and phone number, which then implies a limited patient choice. So the statute just does not allow the advertising piece of it. They could use the form if it did not have any of their identifying information.
That's helpful.
Thank you, ma'am.
Board members, any additional questions or discussion?
Madam Chair, are 13 B, C, and D the same?
I believe so.
C and D are similar.
Yeah, C and D are.
They are owned by the same holding company, but different facilities, different branches, I believe.
Right.
And C and D, I think, are a little bit different than D.
Okay.
At least from my read.
Madam Chair, hearing that
Go ahead.
Mr. Reese has gone on record saying that the title on top of the form will not be accepted at their pharmacy and the other disciplines are at a parent company. And Mr. Reese's license is in good standing for your shop?
Yes, sir.
And hearing that the license is in good standing for his establishment, I make a recommendation that we approve its application.
Second.
I have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Hearing none. Thank you, Mr. Reese. Appreciate your time and attendance and best of luck to you.
Thank you all.
Appreciate it. Item 13C, Optum Infusion Services, 500 INC. Dr. Leyba, you also indicated that Optum Infusion Services 501 item 13D is similar. They are two separate facilities, so I think we probably need to take them individually. However, the concerns kind of carry over between both, just for the purposes of discussion. Who was the compliance officer on these reviews?
Ms. Richardson.
Ms. Richardson, can you please give a brief summary of the concerns with the application to the board?
Yes, with Optum Infusion Services, similar to what we were just discussing, they do have referral forms, as they're called, on their website, which are prescription blanks that then have advertising on them that direct them back to that particular pharmacy. This has been an issue, including with our local Optum facilities. These have been on their website for some time and have been asked to be removed. We've been told in the past that they would be taking care of that. It has not been done yet. And this is over the course of several inspections. What they have done to some of them now is they have put a dotted line with a pair of scissors drawn on there, asking the physicians to cut that piece off when they send it back. Therefore, an inspection, we would not see the advertising information, but again, they are still providing it.
Correct me if I'm wrong, but there were also was there some FDA concerns here as well?
Yes, let me see.
Or
which
was that,
one we are looking at.
Was that a different one from memory?
Let's see. The first one, I don't.
No, it doesn't.
see
No, it doesn't look like
No.
it. Looks like it's the same issue between the two, and it's. Do we have anybody available from Optum Infusion Services?
Yes, I am Optum Infusions 501. This is Laurie Meringue.
Thank you. And your position, please?
I'm the pharmacist in charge of the Las Vegas pharmacy.
Thank you, Lori. Board members, Ms. Meringue, would you like to make a brief statement?
It looks like there's one other person possibly. I'm not sure.
Yes, it's me, Yatin Patel. I'm the pharmacist in charge for Irwindale, California location.
Which is item 13C, location 500. Okay, thank you. Would either of you like to make a brief statement before we proceed with questions?
Are you talking in regards to the referral forms?
Yes, please.
Okay. Yes, so we do have the dotted line to detach. If they do not remove the dotted line, it doesn't all come through. So it will, the prescriber signature will not come through on the bottom. So we would have to have them remove the top piece of that referral form if they do fax. But in Arizona, we do have a very heavy sales team that actually prints these without the top portion of the referral form, and they go out and actually sell to our prescribers. They're visiting the offices and actually leave without the top piece in their offices for use. But I have a non-dispensing pharmacy, and what we do is primarily hemophilia therapy out of our non-dispensing site. We see actually very few of these. Most of our prescriptions are coming in e-prescribing for whatever reason. Doctors don't use very few of these. I know Mr. Solari, he likes to see these in the hospital, but we see very few of them. Just for whatever reason, they don't like to either go on the website or don't like to use them.
Thank you. Mr. Patel, anything to add?
I'll echo to what Laurie said. And when last I checked on website, it actually does not come up with the fax number and phone number. So I just wasn't sure if that was enough.
Thank you. Board members, questions or discussion on these two permits?
May I ask both of you or whoever wants to answer this, what prevents you from just removing the top part from your website altogether and be done with it?
I'm going to go with marketing. I will ask them again to see if they will remove it. But I will ask them again, but it is a marketing piece that our corporation has.
And you realize that's what makes it illegal in Arizona. So as long as that's on your website, we have a problem. And so it would be, I guess I would ask that you don't request that, but tell them.
I will do that, sir.
I feel like a slight difference between these two cases versus the other one is we had an attestation from the individual that stated that they wouldn't fill prescriptions that came from those blanks. Mr. Patel, Ms. Meringue, is that something you would be willing to do is to provide an attestation of that nature?
We could do that, yes, ma'am.
Yes, ma'am.
Thank you. Board members, additional questions? Do we have a motion?
Madam Chair, I'll make a motion to approve.
Do I have a second?
Would that be upon receipt of the attestations referenced?
Yes, I should have said that. My apologies.
Can I ask a quick question? I mean, we can wait till after there's a motion.
No, go ahead.
How do we know that marketing is going to agree with this? So are they making a statement that they can back up or not?
Ms. Snare, that my opinion on this is it's not required in every state. Arizona is unique with some of our rules. This is one of them. If a prescriber was going to prescribe and had intentions to go to this website, and they pretty much had already selected their pharmacy at that point, in my opinion. I I do think it's something that needs to be looked at further down the line. I understand the intent is to ensure that the patient has the ability to make a selection on their own. But to me, by the time it gets to the point of going on site, whether it's got the header on it or not, they've intended to go to an opt-in infusion pharmacy. So it's kind of a moot point in my opinion. But having said that, I think if they provide us with the information that we've asked for, just like the other one did, we do need to approve these permits.
I'll second the motion then.
I will get with our licensing department and get an attestation over once our license or before our license is removed.
Thank you. I have a motion and a second. Any further discussion, board members? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion approved for items 13C and 13D pending the receipt of the attestation. Thank you, Mr. Patel, for your attendance, and Ms. Meringue. Appreciate it and best of luck to you.
Thank you.
Thank you.
Thank you. Item 13E, Pharmerica. This looks like, who was the compliance officer that reviewed this case? Or this permit?
That would be me.
Ms. Richardson, can you please provide a brief summary to the board members?
Yes, Pharmerica is owned by Emerita. So similar ownership, same ownership company that we had for the option one infusion services, where we had some prior discipline issues. So again, same ownership. Initially, that ownership was not disclosed on this application. Once that was discovered, we did get an organization chart that did confirm that. They did disclose discipline from 2018 out of Utah. However, they did not disclose prior Arizona discipline from 2020. When I did inquire about this, they did disclose further discipline in Massachusetts, Kentucky, and Nebraska as well. There was also a 483 issued in 2017 that has been included in your packet along with the company response. The Utah location had both sterile and non-sterile compounding issues and a 483 sterile compounding issue, which appears to just be a pattern with the company, which is why we brought this to your attention for review.
Thank you, Ms. Richardson. Do we have someone present on the line from Pharmerica?
Yes.
Can you please introduce yourself for the record?
I'm Robert Holbeck. I'm the pharmacy director here for Pharmerica here in Salt Lake City.
Thank you.
And Chair, also this is Gary Hingelfeld. I'm the PIC here at the One Point Patient Care Tempe location. I see my camera's not working. I hope you can hear through the audio.
Yes, we can. Thank you very much.
Thank you.
Do either one of you want to make a brief statement before we proceed with questions?
Yeah, I can comment on the inspection. In 2017, we were potentially acquiring some business that was in Colorado. And at that point in time, we had to apply for a licensure in Colorado. And part of the consideration there is that we had to have a current inspection by the Utah board. And so I reached out to request an inspection, which we obtained. Obviously, it was a week process with 2 inspectors that really kind of drilled down on 797. Most all the concerns were primarily administrative considerations, for which we corrected almost within the first 30 days after that inspection. However, the board wanted us to attain additional training, which delayed our response to that. We did acquire the training, I think, in January of 18. And we actually brought in a separate consulting group to do that, to spend, it was 80 hours, 40 hours was didactic coursework for our pharmacy team. And included with that was an additional 40 hours of on-hands training by the same consulting team. So we went through a great deal of additional training, which the Board of Pharmacy here in Utah agreed to. And so as of, I think that I sent that to you, the board lifted our sanctions on 1 year early on our probation because of having reached our goals.
And for the board members' edification, I did ask staff to request the most recent inspection from Utah. They are in compliance. Dr. Gandhi, Jennifer, I don't know if either one of you want to comment on the findings from your review of the latest Utah inspection.
Sure, I'll comment. So what we found was that in Utah's stipulation and order from 2017, there was mention of non-sterile compounding SOPs that were deficient. We did request Utah's, their State Board of Pharmacy inspection, which was done in May of 2018, roughly a year later. Their Board of Pharmacy also noted that standard operating procedures failed to address various sterile, non-sterile compounding practices. So there was a repeat pattern from 2017 to 2018.
Thank you. Board members, additional questions or conversation?
Madam Chair.
Go ahead.
How many, did you say 40 hours of on-hands training? Is that what I heard?
That is correct.
Okay, and that, who was that for? Who all had that 40 hours of training?
Myself, 2 other pharmacists that work here.
Okay, and that was done through an offsite contract, or was that in-house training? What was that?
No, that was done through an offsite contract group that was approved by the Board of Pharmacy here in Utah.
Okay, thank you.
Board members, any additional questions? Suggestions on a motion?
Madam Chair, knowing that they are off probation and there is a shared service agreement in place, they have leadership training that has gone through at least 40 hours of contracted training, I feel that we should approve this application, and I'll read my motion.
I'll second that. I have a motion and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Sounds like Mr. Goodman is back for the record. Staff, if we can note the time that he returned for the minutes.
Goodman returned at, I returned at 11:01. Thank you.
Thank you, Mr. Goodman. Thank you both for your attendance today. Best of luck to you. Your license has been granted.
Thank you.
Thank you.
Thank you. Item 13F, Pharma RX Services. Ms. Richardson, I believe you're the compliance officer on this one as well.
Yes, Ms. Walmsley. The board reviewed this application at the previous meeting. And at that time, the board had concerns with the application, asked the applicant to revise their application with some requested and corrected information. We had an issue with their DBA had not been listed. And there was also a concern with their phone number that had been provided on the application. It was not a landline and had been flagged at that time when I had done the initial review as a spam caller on various consumer websites. During that meeting, they indicated that the phone number was temporary and that they now had a functioning phone number for the pharmacy. Actually, during that meeting, I called the number on the application. It had a voicemail indicating that I had reached the office of Hassan Chami, who is the PIC that did appear at that meeting as well. They did revise their application and provide that to us. It does now indicate Nationwide RX as their DBA. However, the phone number on their revised application is the same. I did call that number again on April 14th. An individual answered the phone number as a personal phone, not as the pharmacy. Additionally, on the original application, they did not disclose ownership of Acutus RX, which is a pharmacy that was issued a non-resident permit in Arizona in 2017 that expired in 2019, closed for non-renewal. the New York board records do show that that pharmacy relocated within the state of New York and still has an active permit. That information was also requested to be corrected and disclosed, and it has still not been disclosed on the revised application.
Thank you, Ms. Richardson. Do we have anybody on the line from Pharma RX Services,
Yeah.
DBA Nationwide RX?
Yes, this is Harpreet. I'm the owner. So sorry, I was on mute, and by the time I heard, I think.
Ma'am, Harpreet, you're muted. We still can't hear you.
Can you hear me now?
Yes, thank you.
Okay. So if I understand, was there a concern with the phone number?
Yes, it appears that we still have two concerns that remain from the last meeting. Apparently, there are still some concerns regarding the phone number that you have listed on the application being a personal line versus a business line, as well as the issue of the outstanding permit in the state of New York, if I'm understanding correct, Ms. Richardson.
So I'm actually surprised the phone number was corrected when we sent the revised application. I don't have access to the application, but I will look into that. How can I get back to you with the phone number? I can give you our corrected phone number right now. Would you like me to confirm? The pharmacy is active.
I'd like some guidance from staff. Ms. Galvin, Ms. Richardson, what is the appropriate format to do that? Do we need to table this and have them review the application, revise their application further, or what's the best way to address this?
There are other concerns from the record and in my notes of Ms. Richardson's summary, besides the phone number that you may want to discuss with the owner.
Madam Chair,
Yes.
why, maybe I'm wrong, but why did we found one pharmacy that was not disclosed on the original application, and now, am I reading this right, that there's another pharmacy that wasn't disclosed? Ms. Richardson, or am I behind?
No, Mr. Leba, it's the same one.
Same one that's not disclosed, okay.
Correct.
Thank you.
So that Acutus RX pharmacy was actually in business in 2017, but sold in 2019. The new ownership is using the DBA as Acutus RX. It's not LLC anymore. Plus, they're not licensed in Arizona. So it's just a matter of, Arizona Board of Pharmacy deactivating the license, but that LLC is no longer in business. That pharmacy ownership was actually the owner, myself being the owner, we sold the pharmacy, the books to another pharmacy. So it's not an active license. So I'm not sure where it's coming up, but it's, it's not, unless I need to call someone and deactivate the license. We did send out an email letting them know that, the pharmacy was sold. So to deactivate all licenses, we went through an agency, third-party agency called License Logics. Unless there's something missing, I'm not aware of, but Arizona is definitely, I checked with the owner, they're not doing any business with Arizona.
That's not consistent with our records, correct, Ms. Richardson? Their permit still shows active.
Ms. Walmsley, no, it was closed for non-renewal, so it is a closed status. The issue was non-disclosure. The application does ask if they currently operate or have ever operated a similar business, and this particular pharmacy was not disclosed as ever having been owned by this particular owner.
Thank you for the clarification. Board members,
Galvin,
additional questions?
I have one.
Yes.
Ms. Galvin, could we just call this number right now and see picks up?
You may.
Ms. Richardson, can I put you on the spot to do that? You're on mute, Sharon.
Yes, I will do that right now.
Nationwide Pharmacy, how can I help you?
Hi, who am I speaking with?
Hassan Shani.
Okay, any questions for the board? You're muted,
I
Jim.
would like to know if this is a business, if he's physically inside the permitted pharmacy.
Yeah,
Mr.
you can actually turn on my camera and you can see me hold it.
Okay.
Under Sunny Shami. I can give you a tour of the pharmacy if you'd like.
So he is on the call with us under Sunny Chami, Chami. His camera is off, however.
Yeah, I think
Sunny, can
that's,
you turn on the camera, please? Can you
There he
turn
is.
on the camera?
Can I hang up?
Can you show us the pharmacy real quick, like you said?
Yeah, 1 second. Can I hang up on this phone? It's the same.
I think you can because you're on the board. Yeah.
1 second. I'm actually I'm on my computer. I'm going to log on to Zoom on my phone and I'll take you guys around.
This will get to the bottom of the phone number.
Yeah, was it the 855 number you guys called? 8100108?
No.
379-8483?
Yes.
There's a local line and a toll free.
Okay.
All right, am I in on this?
We can hear you.
Yes, you are.
I'll walk on one second.
Recording in progress.
Not letting me change the camera. All right, there we go. Okay. So, this is just an alternate.
I think you're on mute on your phone with the view, Sunny.
All right, can you hear me?
Yes.
All right, so this space is going to be cubicles for technicians, but we currently have the technicians working out of here. So this is the pharmacy, and that we can show you. You're on Nationwide right now, so we can show you the prescriptions that they're working on. Go to Nimble or something.
Let's not
Any, if you can-
share any patient information.
Yeah,
please.
yeah. There's no patient information there, so he's working on that, and then we'll show you the back where the gentleman is packaging.
What, Mary?
So this is the back of the pharmacy. So the gentleman works on the POS, the packaging. Here are the drugs that we package.
Is that the entirety of your inventory that you have on those shelves?
Yeah, so right now we're only working with one specific program. We're working with the Astrino program like we spoke about before. So we currently just focus on, actually I can show you the list right now. We currently focus on 13 NDCs. So this is like, it's a cash only pharmacy. So it's for patients who don't have, these medications are not covered by their insurance contracts. So the doctors send them to us and we give them the rebate deal that we have here with the Astrino Pharmaceuticals.
And if I recall, no controlled substances were confirmed last time.
What is it?
I think last time you confirmed that there was no controlled substances in inventory or dispensing.
So sorry, you went out.
That's correct. We do no controls.
Yeah.
Mm-hmm.
Here is the it's a mess. Let me see here. All right, so here's the Astrino Premier Savings Program. These are the drugs that you guys seen.
Okay.
And we can send you guys that in an email.
Thank you, Mr. Chami. Board members, additional questions?
Ms. Walmsley, may I?
Yes, please.
Mr. Chami, if I'm a prescriber or a patient and I want to speak to a pharmacist, is that the number I call? And if I called it, would I get you? Are you the pharmacist there?
I'm the pharmacist here.
If I call that number, I'm going to get to you to talk to you.
Yep, or a technician will answer and you ask to speak to the pharmacist and it's forwarded to me.
Okay, thank you.
We have a local number and a toll-free number that can be dialed.
Madam Chair. Seeing the operation, having the phone call answered, understanding that the last permit was closed. I think that should have been communicated, but it is closed. I don't see a reason that, although it may not look like your standard pharmacy that we're all used to seeing, it is a pharmacy with the definition. I don't see a reason that we can not approve this application. It'd be my motion to approve the application.
Second.
Board members, any additional discussion or questions? All those in favor?
Aye.
Aye.
Any opposed? Thank you both for your attendance today. Best of luck to you.
Thank you.
Thank you.
Item 13G. This is United Apothecary Inc. DBA Riddle Drugs. This is, which compliance officer had this one?
It's mine, Ms. Walmsley.
Okay, can you go ahead and give us a brief summary, Mr. Hyber?
I'll be happy to. As you know, we do a substantive review of new permit with this particular applicant, which is a facility located in Tennessee, an existing facility that's located in Tennessee. We noted that one of the officers held a pharmacist licensed in Tennessee, and diving in a little bit deeper, we found that there was some undisclosed discipline, at least insofar as the application, that Jared Grant Riddle had some discipline on his license that was imposed back in September of 18 for, based upon a routine inspection that was conducted in March of 2017. And we got a copy of the consent agreement. It's within the packet. And basically there was some consent with a fine basically imposed for an admission of not performing final verification of the product prior to dispensing a prescription.
Thank you, Mr. Hyber. Do we have anybody on the line from United Apothecary Inc. DBA Riddle Drugs?
Yes, Grant Riddle.
Mr. Riddle, can you please state your position for the record?
I'm the Vice President of United Apothecary, and I have worked as a pharmacist.
Do you still practice as a pharmacist in the pharmacy, Mr. Riddle?
I have not in probably about a year or so.
Do you plan to do so?
No, I do not.
Okay, thank you. Board members, I want to call your attention to two items. Mr. Riddle is an officer of the pharmacy, and there was the conduct that was disclosed for which he was disciplined for by the state of Tennessee. Mr. Riddle, is your license now in good standing?
Yes.
Okay, thank you. The other matter that I think the board needs to just briefly look at is Charles Murphy is listed as the PIC. He also has a disciplinary action from 2003 from Tennessee. That's located on page 2191 of your book. Again, it does appear that this individual is in good standing. There is some confidentiality with this case, so just note that as we discuss here. Board members, other points of discussion or questions for Mr. Hyber or Mr. Riddle?
Madam Chair, may I ask a question?
Go ahead.
Mr. Riddle, I know you're the vice president there. Are you intending to work any shifts in this pharmacy on a staff capacity?
No, no, sir.
You're not going to touch anything in there, just owner?
Yes.
Okay, thank you.
I have a question about the non-verifying medications before they left the pharmacy. What was the process there?
That was something that was done by a pharmacist who had been working there. She is no longer with our company, but even though she's the one who did not verify that medications went out, I was the pharmacist in charge at the time. So ultimately and rightfully, that falls on me to make sure that that happens.
My next question was about the accepting medication returns and reusing them for other patients. Can you speak to that question as well?
Yes, that was also done by the same pharmacist and instructed that we should not do that. And again, that was something that as a pharmacist in charge, I am responsible for. And I instructed them to not use medication that had been returned as stock.
Is that included in your policies and procedures that you would not accept products for resale?
I don't know if I specifically have that in there, but I would add it.
Okay, thank you. Board members, any additional questions?
Madam Chair.
Yes.
Since that, Mr. Riddle, have you had an inspection with the Tennessee board, and how did that go?
Yes, we've had routine inspections. And this actually took place at another one of our locations, other than the one that we're applying for the non-resident pharmacy license. But yes, we've had inspections since then at the locations, and all inspections have been fine.
Okay.
Madam Chair, this is Kevin.
Yes, go ahead, Kevin.
So, Mr. Riddle, just to ease my mind, and I'm sure to ease other board members' mind, can you send to the board board staff the revised procedures that include the language of not accepting the returns medications and making sure that the medications are verified before they can dispense?
Sure. Yeah, we can do that.
Thank you.
Board members, any further discussion?
Jennifer, I just have a comment. I just wanted to remind the board members that Mr. Riddle's prior disciplinary action was not disclosed on his application.
Thank you, Jennifer.
Was a complaint open on that because he's not listed as, it's not listed on this permit? I'm sorry, is he licensed by our board?
He is not.
Okay, then never mind.
I don't believe so, at least from looking at this. Board members' thoughts on a motion?
Is Mr. Murphy the pick, or is he going to be? Okay. And I don't know if this is an appropriate question, is he under some kind of contract of some sort?
It looks like that was resolved. The matter was from 2003.
Oh, thank you.
Yeah, if I may, the PIC prior discipline was disclosed on the application. And yeah, his license, he's cleared that prior discipline now. He's in good standing.
Thank you.
Board members, additional questions? Any suggestions on a motion?
Madam Chair, this is Kevin. Since he didn't disclose the previous disciplines on the application, can we impose a fine of $250 and then grant him the license?
That would be on the permit?
Yep.
Madam Chair,
Yes.
Mr. Riddle, why didn't you disclose?
An oversight, really. I should have.
Did you fill out the application?
It was done by License Logics.
Sounds like, so you approved it, is what it sounds like.
Yes.
Mr. Riddle, George Riddle's e-signature is on this application.
Yes, that he is the president of the company. Yes.
So Mr. Dang had a suggestion of approving the application with a $250 consent for failure to disclose. Any additional thoughts on that as a motion? Or do we have an alternative? I don't know if that was an actual motion or just a suggestion.
It's a suggestion. If there's no other input, I will make that as a motion.
This, Kevin, there was 2 non-disclosures on this application, right? They had a chance to disclose 2 from they did the pick, but not the owner. Correct?
Mr. Leba, they disclosed the PIC prior. They did not disclose the officers prior.
Okay.
Perhaps a letter of concern versus a consent agreement. Just a thought. I mean, I don't know if it was that there was intent to do it. If there was intent, I think they probably wouldn't have disclosed either. I understand that there can be some things that are occasionally missed based on that, especially with the licensing agency doing it, although it is the responsibility of the owner to ensure that the application is correct and whoever's signing off on it. Just an alternative thought out there.
Madam Chair, I see your point, but I just want to make sure that we, as a board, stay consistent with all the actions that we have voted on over the past years.
Madam Chair, can I make a comment real quick? This license is
Yes.
probably one of the most important things that he's going to fill out and make sure that he sends in correctly. And if it's just an oversight or not paying attention to this, what else is there not going to be paid attention to? I think we should deny the application.
Chair, this is Goodman as well.
Yes, Mr.
I
Goodman.
I concur. You know, if he's not taking this seriously, and then there's a little bit of, oh, I didn't fill it out. Well, you signed it, you approved it, it's your application.
I feel.
Did you say something, Mr. Riddle?
I would hope that I mean, all I can say is that it was, in the end, it is my mistake of not doing this. And all that I could say is that I would do my best to be thorough, but that's all that I really have in my defense.
I don't want to not give the license or permit because of that. I think Mr. Dang's idea probably be the best middle ground here.
I agree, because I think by imposing a $250 fine, at least it stays on the pharmacy license records. And I think we should grant him the license, and at least he will learn from the $250 fine and take that as a lesson.
Have we done that before? I know you're concerned about being consistent. I don't know if we have or haven't done that with it.
I just based on my recollection, if the applicants fail to disclose any type of information, there is some penalty in monetary values, but I don't remember the exact amount. So I'm just throwing out $250. If Ruben and Mr. Goodman, you guys want to bump up that fine, it's fine by me.
Well, the other thing to keep in mind too, since they're licensed in a number of states, they're also, this would be discipline. So they would be required to report that to all of those other states as well.
True.
Yeah, this is Goodman. My view on this particular one hasn't changed, and it doesn't have to do with a penalty amount. I do have probably not to solve it right now, but a general question. I keep hearing with the pharmacy board, the importance of following precedent. Precedent gets put into rule when we have to follow it. Every case should be measured in its own. Whether we did it on the last case or the next case, I don't think we want to be in the spot where we only do penalties aligned with what we've done previously. Just my take.
Right, but we don't want to be arbitrary. So
true.
I don't think that we have to follow it, but just being consistent or giving a reason why we're not staying with what we've done in the past, I think is important. I think we can vary if the circumstance calls for it.
Thank you. Yeah.
In my opinion, I generally agree with Ms. Snare. I don't think these guys are a danger to Arizona citizens. I don't think their pharmacy operations are in question. It's just he neglected to disclose something, and Dr. Dang is right. Typically with non-disclosures, we have some kind of a civil penalty, but I don't see them as a danger to Arizonans. I don't think their pharmacy is a problem. So I generally, having heard the three different arguments, I tend to agree with Dr. Dang and fine them for non-disclosure and then approve their license.
I agree. I don't think that they're a danger to the state.
That's your motion, Kevin?
Yes, so I'll make a motion to grant the license and impose a monetary fine of $250.
Is that grant upon signing a consent agreement for a civil penalty? Or is it grant upon signing and granting is subject to the payment of the penalty? And if so, what's the time frame for payment?
I would say he wants a license as soon as possible, so let's make it within 30 days.
And is the granting contingent upon signing the consent or receiving payment under the consent?
Receiving payment.
Or deny?
Or otherwise, we're going to deny, yes.
Amended second.
I have a motion and a second. Any further discussion? Mr. Hargraves, do we need a roll call on this one since it includes a consent?
Yes, you do, Madam Chair.
Go ahead.
Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Hey.
Mr. Leba?
Couldn't hear you, Joe.
Aye.
Ms. Lahan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
No.
Ms. Nair?
Aye.
7 ayes, 2 nays. Madam Chair, motion carries.
Thank you very much. Mr. Riddle, thank you for your time and your attendance today. Best of luck to you.
Thank you.
All right, let's try and get through a few more items before lunch. Tab 14 is vacant. tab 15 is non-resident wholesaler permit applications requiring board approval. This is Women's Choice Pharmaceutical application for a non-resident pharmacy. Looks like Ms. Richardson, you were the compliance officer that did the review on this.
Yes, I was.
Can you please give a brief summary?
Sure. Women's Choice Pharmaceuticals had a full service wholesaler permit with this board from 2016, March through 10/31 of 2016, at which point it expired. In August of 2017, they attempted to apply for a new full service wholesaler permit. That application was closed, and instead they were instructed to renew their expired permit. They did renew that in 2017. It again expired in 2019. The current status of that permit is closed for non-renewal. The address of the permit was located in Mississippi. On January 16th of 2020, they once again applied for a full service wholesaler permit, this time with an address in Pennsylvania. During the substantive review of the application, which occurred in May of 2020, it was determined that they had relocated from Mississippi to Pennsylvania on January 1st of 2019. In addition, they had been shipping products into Arizona from this non-permitted location since their move. During the review, it was also discovered that they had purchased a company by the name of Edwards Pharmaceuticals in 2014. They do hold a wholesaler permit with this board, or did, I'm sorry, from 2011 till 2018. Again, it is closed for non-renewal. The address for Edwards Pharmaceuticals was the same address as the Women's Choice wholesaler permit in Mississippi. At no point was the required change of ownership applied for or completed, nor did Edwards notify us of the changes required. The ownership also was not disclosed on the Women's Choice application from January of 2020. In December of 2020, the board issued a cease and desist order to Women's Choice to no longer ship into Arizona, as they were not in a permitted facility. At that point, the staff was informed by a representative of the company that they were a virtual manufacturer and not a wholesaler, despite the fact that they had been permitted as a wholesaler since 2016. They have now applied for a virtual manufacturer permit as well. The manufacturer permit application was filed in January of 2021. It lists 3 CMOs that are being used by Women's Choice, none of which possess a required permit in Arizona. That manufacturer permit also does not disclose the ownership of Edwards Pharmaceuticals, nor have they disclosed any other permits that they hold in other states. These other permits were not disclosed on the wholesaler application either, but after a search discovered them, a list was provided on request by the board. Both the wholesaler and the manufacturer permit applications are presented for your review and decision today. And I'm open to any questions.
Thank you, Ms. Richardson. Looks like we have somebody on the line from Women's Choice. Can you please introduce yourself and your position for the record? Mr. Allen, we can't hear you. No, we still can't hear you. No, still cannot. It doesn't look like your computer's connected to the audio. Board members, while Mr. Allen tries to connect to the audio, do we have any questions for Ms. Richardson regarding the application?
Ms. Walmsley, can I make a clarification also to what I had stated? The manufacturer application for virtual manufacturer actually is not being presented to you today. We have not passed it through the substantive review yet because they're contract manufacturers. do not possess a required permit. So all that is before you today is the wholesaler application and the issues that we discovered with that.
Thank you. So we did issue a cease and desist, and it appears that this organization continued to ship after the cease and desist before they were licensed in the state. Is that a fair statement?
I believe that they no longer shipped after the cease and desist. We had also contacted the third-party logistics firm that they used to ship, and they were instructed as well that Women's International or Women's Choice did not hold a valid permit for Arizona, so they were no longer shipping on their behalf.
Okay, but they did ship for a small period of time between when their permit expired and
Correct. They shipped from January for basically a year, from January 1st of 2019 until the cease and desist in December of 2020.
Okay, and we do we have a summary of the amount of items that were shipped into Arizona without the permit?
We did receive that from the 3PL.
Okay, thank you. And sounds
Good
like
afternoon.
we have
This
Mr.
is-
Allen connected. Thank you.
Yes, via phone. I apologize for
No
the
problem.
technical difficulties. Thank you.
No problem. Can you please introduce yourself for the record and state your position?
Yes, my name is David. Sure. My name is David Allen. I'm the Vice President of Supply Chain Management for Women's Choice Pharmaceuticals as well as Edwards Pharmaceuticals.
Thank you, Mr. Allen. Did you hear Ms. Richardson's concerns that she raised with the board regarding the application?
Yes, up until I was frantically calling in to try and
Okay.
participate in the meeting. So,
Yeah, no problem.
From a little bit of background information is we did have some turnover in personnel that happened towards the back end of 2020. So the first that I was brought to the attention of Arizona was unfortunately around the cease and desist. And I would like to add that all the folks that I've been communicating with via email have been incredibly responsive and helpful. So upon understanding and the reasoning behind the cease and desist, it looked like or sounded as though there was some prolonged communication between the person who used to handle the state licensing responsibilities for us and Arizona, and it came to the surface rather quickly that we were pursuing an incorrect license. So while there is some discussion around we were shipping into Arizona, it was unbeknownst to us that particularly me personally, that we had an incorrect license. Upon receipt of the cease and desist, and I happened to be at our 3PL, Rainbow Gold 3PL in Alabama, the date of that they received that communication, we discontinued shipping at Arizona's request. We discontinued shipping the items in immediately.
Thank you. Board members, any questions for Mr. Allen or Ms. Richardson?
So, Madam Chair, may I speak?
Yes, please.
There's a lot of problems with this. I counted 6 issues, and I'll take them one at a time. Maybe Mr. Allen can address them. You relocated from Missouri to Pennsylvania without notifying us. Why did you not notify us?
No, so the background is Women's Choice Pharmaceuticals originated actually, as it would turn out, in Arizona and Gilbert as a manufacturer as well as distributor. That location was shut down and related to the acquisition of Edwards Pharmaceuticals that was mentioned previously. At that point, Arizona's facility and all their responsibilities as far as shipping was all contained under one roof in Mississippi, Ripley, Mississippi, Edwards. So at that point, we were continuing the as a manufacturer, wholesale distributor. It depends on the state that I've learned in a short amount of time. Each state is different as far as how they even identify you. And as was mentioned by Ms. Richardson, the facility in Mississippi was shut down in January of 2019. At that point, we just have corporate headquarters in Pennsylvania, and we outsourced all of our distribution to a 3PL, Rainbow Gold 3PL in Gunnersville, Alabama. So we are a true virtual company for both Edwards and Women's Choice Pharmaceuticals. And while ignorance is no excuse, quite honestly, with a valid permit, and we're very lean and small organization. At that point, we're frantically trying to renew licenses, and when they would come up, then we would communicate a renewal, our status as what we were upon the renewal, if that makes sense.
I guess so. So the reason you didn't notify us is basically you're saying is because you didn't know. Am I understanding that correctly?
Well, yeah, personally, that would be the avenue that I would go, is that all of our licensing and permit acquisitions were handled in Ripley, Mississippi. When those responsibilities shifted to the person who's no longer with us in Pennsylvania, at that point, it's clear that the communication did not happen.
I am a little bit unclear. Do you want to be a wholesaler and manufacturer or a virtual manufacturer, or is it all the above? What is it that exactly you want?
No, we are only a virtual manufacturer. That's all we will ever be.
Which they have applied. This permit is for a non-resident wholesaler permit. So right now, the application in front of us is not the appropriate permit type. I believe we've received a request to withdraw, and they're working on the application for the other type of permit that is the appropriate permit. Is that correct, staff?
That is correct, Madam Chair.
That's not what I had in my recollection and or notes. Is that we were pursuing, as per the guidance of Arizona, the non-resident virtual manufacturer license. That's what we applied for Women's Choice. It was originally being pursued incorrectly. That's what came to the surface very quickly in January of 2021, when the cease and desist came to my attention. My communication with Jennifer, and I'm sorry, I don't want to butcher the last name, starts with a K, Connor, as well as Cam Gandhi, was that we were historically pursuing the incorrect licensure. At that point, my intention was to pursue the non-resident virtual manufacturer license, which I believe I did.
That is not what is before us today, just for the record, Mr. Allen. The virtual manufacturer permit is still undergoing the substantive review, and there are some pieces that are missing with that, specifically the CMO for the manufacturers.
I understand.
With this.
I understand.
So,
thank you.
Board members, any additional questions? Otherwise, I have a suggestion on perhaps how to address this.
Madam Chair, if I may.
Wrong thing. Yes, go ahead, Cam.
I can interject. So just for timeline purposes, they had moved January of 2019, but their initial application to us, which is the wrong application, the wholesaler, didn't come in until January of 2020, an entire year later. So I just wanted to point that out.
Madam Chair?
Yes, go ahead.
To me, what we have before us is shipping for that year. And previously, what we have done as a board is allowed the ability for the ED and deputy director to work with the permit holder on a agreement and enter into a consent agreement for the number of times that they shipped into Arizona without a permit. And that would be kind of what I'm leaning at. And I think definitely that AG is involved in that, drafting the consent agreement as well. And then it comes back before us when that is done. That's where I would kind of lean on this one. And then when the virtual comes before us, that's a whole different topic. That's just an opinion to offer.
I was kind of leaning towards the same direction. So my thought was it doesn't, the consent agreement for the shipping to me takes care of the majority of their concerns as long as the application is complete and the substantive review is completed for the virtual manufacturer, which appears to be the type of license that they're really seeking. So my suggestion was going to be to allow the executive director, deputy director, and AG to work out a consent agreement for that very topic, Dr. Leba, around the shipping without a license. And then if paid and signed, allow them to conditionally approve the virtual manufacturer permit, provided that we've received all the required materials that are able to complete the substantive review in time. At that point, that could end up on the consent agenda for a future meeting and we don't have to deal with it. If for some reason they're not willing to pay or do any of those other kinds of things, then we would deny the request to withdraw, and the other application would be closed if not done in time, and the fee would be forfeited.
I'll second.
I just want to make sure I understand this correctly. You're going to allow them to withdraw their wholesaler permit after they sign the consent agreement, or is the consent agreement for approval of the virtual manufacturer license?
It would be conditional for the approval of the virtual manufacturer, which is the license type that they actually need.
You're not asking them to do anything to allow them to withdraw the wholesaler
the withdrawal of this license would be conditional upon the payment of the consent agreement and the application of the otherwise this application would be denied, is my motion.
And I'm okay with everything you said, but there was a lot of violations here, not just shipping into Arizona without a license. There was a relocation from Mississippi to Pennsylvania. They didn't notice us. Shipped into Arizona. We talked about that. They purchased Edwards Pharmaceuticals without submitting a child. They have 3 CMOs that were not licensed in Arizona. They did not disclose other permits in other states. And they shipped the Urogesic into Arizona without a permit until they got the cease and desist order. I just wanted a little bit more a little bit more stronger language than just, I don't know. I feel like the violations are greater than just shipping into Arizona without a permit.
Mr. Solari, Madam Chair, if I may, those
please.
points are noted, Mr. Solari, and we can definitely, when we craft the consent agreement, we can note those violations and have a discussion and wrap it all up in one. Just a point of clarification, Madam Chair, the civil penalty consent agreement, if we come to an agreement, would that go on the manufacturer's permit?
I think it would be appropriate to tie it to the permit that's being issued. The virtual manufacturer. If we get to the point that it's issued, otherwise it should be tied to
Experiencing unstable internet connection. So if you can repeat that, I didn't catch your answer. Would that go against the manufacturer's application permit?
Yeah, the virtual manufacturer.
Okay, perfect.
Any additional discussion? Otherwise, I have a motion and a second.
I have a comment.
Yes.
As far as the virtual manufacturer application is concerned, it is approaching the administrative review timeframe deadline in terms of Mr. Allen responding with the CMO information. So as of right now, that application is set to close and fee be forfeited on May 20th of 2021.
Was that for the virtual? Is that what you said?
For the virtual, and that's based on a statutory timeframe.
Could we extend it, knowing that we're working on this?
Maybe Mr. Allen, we should ask, do you need that to be extended, or is that something?
That would be ideal based on the details that I'm that I'm assuming would come my way surrounding what I could communicate within our internal team. And then it really creates a pathway around communication as well as an endpoint for a solution. We desperately want to be in good standing with Arizona. It's never been our intention to cause confusion and or to step out of bounds. And like I had mentioned, is that while the ignorance is no excuse, I'm sure you understand and deal with a lot of situations that are confusing from your end that in retrospect, we could have done things a lot better, and we will. So it's just a question of appreciating your patience, number one, for the missteps historically, but then our understanding that we're anxious to do what's right for Arizona and the patients that are within the state.
Are you licensing the CMOs?
Yes, that's right. That's our pursuit, but we just wanted the clarification is that it seemed like there was a little bit of a misunderstanding from our end surrounding the request, because as mentioned is that while I have been dealing with this topic firsthand since the beginning of this year, is that there are different states and different approaches to a virtual manufacturers. So it was somewhat surprising as far as the request initially. So then it is our intent as far as once we have the history clarified, then it'll help us better pursue the future as far as what we need to do.
Ms. Walmsley, this is Sharon. If I can just clarify for Ms. Snare, the CMOs, it is going to be incumbent upon them to apply for manufacturer permits with this board. So whether they do that or not is probably going to be out of control of Women's Choice.
Thank you. I misunderstood that. Thank you.
And that was a question I had as well, is that if one of the contract manufacturers to that point saying, well, listen, we're not interested in pursuing the Arizona licensure or permit, would that remove the ability for us to distribute any products into the state or just the applicable product?
It would just be the applicable product that particular CMO makes. Any product that you ship in that is made by a contract manufacturer, that particular CMO would need to be permitted in Arizona.
And we would like.
I understand.
And Mr. Allen, we would like an attestation that you will ship products manufactured by that unpermitted facility.
I understand.
Yes, Dr. Leva.
Having said that, if there's a chance the CMO may not agree, should this consent be towards this license in front of us?
This is not a currently licensed facility. This is a license application that they are requesting to withdraw.
Okay. So they could not do the virtual as well if the CMOs will not
agree to that. Yes.
That's where my thought process is going, but I don't know how to formulate a solution to that.
Ms. Galvin, do you have a suggestion based on kind of the intent of our conversation? Are we on the right track from a legal perspective, or should we table this and bring it back to the next meeting?
I would defer to Seth if you have any suggestions.
I guess maybe I'm partially confused. Is this a new application or a renewal? Because it looks like they had one at one point, but then they were shipping after it wasn't renewed. And would this be a renewal or a new application that they're now trying to withdraw?
This is actually a new application. Since they relocated across state lines, we're not able to do a renewal.
So this is a new application currently for a full service wholesale permit. However, they actually need a virtual manufacturer permit, a virtual wholesaler permit, I'm sorry.
And Mr. Hargraves, we have that application. It is just under substantive review. Or
Okay.
administrative review.
And it's still within that first 120 days?
It is, and the time frame expires 5/20, and it looks like Mr. Allen has asked for an extension.
Right, and under the rule 602 C5E, the applicant and the board can mutually agree in writing to extend for no more than 45 days that substantive review timeframe. So that may be something that should be looked into, whether or not things can be done within that timeframe. And I guess we'll have to wait and see. Maybe it would be best to kind of table consideration of this until we see where that process goes, and that may help try to figure out how to proceed.
I believe our next meeting is further than 45 days away, is it not? Is there any concern with that?
You could wait to extend the time frame an additional 45 days till the current time frame expires. I believe it was on 5/20. So that will buy us a little bit more time. If there's information that you can request, then that would toll the time frame from accruing.
So I would, if I can, I'd just like to make a clarification on their 90-day. It appears we notified them on March 1st. We notified them on March 1st, so their 90-day time frame appears to be July 8th. I want to make that clarification.
So that may give you enough time.
So they have until July 8th to provide all the information for the substantive review. Just to make sure that I understand.
Yes, and that time frame can be extended if the parties agree.
Mr. Allen, is that acceptable?
Yes, it is.
You think you can get everything submitted by July 8th?
Yes, I can.
The CMO or the attestation that you won't ship in the products that aren't listed, that aren't licensed as a CMO in Arizona?
Yes.
Okay, so you don't feel like you would need an extension beyond the July 8th date?
No, I mean, as far as the 60 days from this point, almost, I think that's enough time. I just would certainly to have an answer surrounding whether or not we would have our partners be able to pursue the correct permit.
Okay, I appreciate that. Board members, any additional questions? I think we had a motion and a second on the floor. Ms. Galvin, is it appropriate for us to act on that motion, or would we be better off to table this until the next meeting?
That's really up to the board, how you want to proceed.
Any additional discussion on the motion? Go ahead, Mr. Goodman.
Yeah, can we repeat what the motion is, given all the discussion in between? We want to make sure we're all on the same page.
Well, and can I ask a question before you repeat it, because it might play into it? If we act on it now, would that give time for the consent order to be drafted in between?
I'm sorry, I don't understand that.
Everyone looks confused.
Ms. Nair, if I may, it depends on our discussion and then whether we can both come to an agreement.
Okay.
If we can come to it quicker, then I think we possibly can. But if it drags on, then, so it's all dependent. That's rate limiting right there.
Okay. Proceed.
So my motion was originally to allow the executive director, deputy director, and board counsel to work out an agreement, a consent agreement for the shipping without a permit for the period of that 1 year when they did not have the permit. If paid, allow them to withdraw this application that is incorrect, provide it and conditionally approve the virtual manufacturer, provided that we have received all of the information that is required within the time frame that is required for the license. So receipt of the CMO and or the attestation that they will not ship products in that are not licensed as a CMO in the state of Arizona. If the information is not provided within the time frame, we could either close the application and the fee would be forfeited, and the request for the withdrawal would be denied.
My second.
Is everyone clear on the motion? Any additional discussion? Dr. Gandhi, roll call, please. Because I think there's no, this isn't a consenting. Do we need a roll call or not?
You would, because you're seeking a civil excuse me?
Yeah, let's just do one, Madam Chair.
Okay, go ahead.
Mr. Solari?
Aye.
Mr. Dang? Mr. Minkus? Mr. Minkus? I'll come back.
Sorry, I was muted. Aye.
Aye. Mr. Leba?
Aye.
Ms. Lehan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
No.
Ms. Nair?
Aye.
Okay. 8 ayes, 1 nay. Motion carries.
Thank you, Mr. Allen, for your attendance today. The staff will be in communication with you on next steps. I appreciate your attendance.
Thank you very much.
All right, board members, the time is almost 12:15, so I would suggest that we break for lunch now. Are we ready to come back at 1 o'clock or?
1 o'clock.
Okay.
1:15.
All,
One's
if we have
one's
stuff
fine.
notice for 1 o'clock. All right, we'll return at 1 o'clock. And then Dr. Gandhi, I believe we've, have we heard from Mr. Bozen about the case from earlier today?
We have individuals available till 3 o'clock today and until noon tomorrow.
Okay.
So I will relay that to Mr. Bozen.
Looks like he's on the line. Mr. Bozen, when we return, we'll do conferences and then we'll move to your respondent. Two of the conferences really aren't going to be there, so it probably will be closer to 1:30, 2 o'clock, I would guess. But sometimes directly after lunch.
I'll make sure he dials in. Thank you.
Thank you. Appreciate it. All right, let's recess for lunch.
Thank you, guys.
Dr. Gandhi, does it look like we have everybody to go ahead and get started?
It does. I can take roll call, Madam Chair.
Okay, it is now 1:01 and we'll resume the meeting from our brief recess. Dr. Gandhi, can you please take a roll to reestablish the quorum?
Certainly. Mr. Solari?
Here, sir.
Mr. Dang?
Here.
Mr. Minkus?
Here.
Mr. Leba?
Here.
Ms. Lehan?
Here.
Ms. Walmsley?
Here.
Mr. Tong?
Here.
Mr. Goodman?
Present.
And Ms. Nair?
Here.
All accounted for, Madam Chair.
Thank you, Dr. Gandhi. Moving on in the agenda, tab 16 was vacant. We'll come back to 17 since the conferences are time sensitive. Conference number 25A 21-0015. We'll get to that in the book here.
Madam Chair, if I may jump in.
Yeah, go ahead. I was going to make a brief statement, but go ahead.
Sure, certainly. When we were discussing this conference, we had spoken to the licensee, and the licensee intention is never to practice in pharmacy again, and therefore has agreed to voluntarily surrender her license. That consent agreement should be in the book itself with her signature on it.
Thank you, Dr. Gandhi. Do I have a motion to accept the voluntary surrender?
I'll make a motion to accept the voluntary surrender.
Second.
Thank you. Dr. Gandhi, roll call.
Mr. Solari?
Aye.
Mr. Dang? Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leba?
Aye.
Ms. Lehan? Ms. Lehan?
Aye.
Okay, Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Aye.
And Ms. Nair?
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Item 25B. This is complaint number 20-0473. John McClellan, the Apothecary Pharmacy. This is a follow-up to our discussion from the last meeting. As a reminder, the complaint from last meeting was related to the significant early filling of a controlled substance prescription of a complaint from a prescriber. During the meeting, there was a lot of discussion, and we advised the staff that we wished to have a follow-up inspection since there had not been an inspection done in several years at this particular pharmacy to ensure that there are no other concerns there. Ms. Richardson and I believe Ms. Dodge visited the pharmacy. If one of you would like to provide kind of a brief synopsis of what your findings were in addition to the discussion that we had at the last meeting.
Yes, Ms. Walmsley, this is Sharon Richardson. Elizabeth Dodge and I did visit the pharmacy on April 5th. When we entered the pharmacy on first note, we observed that it was extremely cluttered. Pictures have been included for your review. The work counter, the shelving above the counter were very cluttered, contained prescription drugs. Some areas of the pharmacy were filled to the ceiling and were inaccessible. Violation for unacceptable facility conditions was issued during this inspection. However, this is the third consecutive inspection in which this violation has been issued. It does not appear that the facility is conducive to the safe and efficient practice of pharmacy. It may actually pose a hazard by providing areas for infestation. We also issued a violation for failure to develop, implement, and review required policies and procedures surrounding several areas: expired drugs, quality assurance, and the computer system. This is also the third consecutive inspection in which these violations were noted. It's the first violation issued for it, however. I did go in and review the controlled substance refill histories for multiple patients since that had been a concern with the initial complaint. There were a couple of refills that occurred maybe 1 to 2 weeks early, but the majority of the ones that I audited were filled just within a 2 to 3 day time period. Didn't seem to be out of the ordinary from the normal practice of pharmacy. And a controlled substance audit was also conducted, and there were no discrepancies found in any of the controlled substances. In your packet, in addition to the photos that we took on this inspection, there are photos from a prior inspection in 2017 where you can compare the similarities between the two.
Thank you, Ms. Richardson. Mr. McClellan, are you present?
Yes.
Can you please introduce yourself for the record?
John McClellan.
Thank you, Mr. McClellan. And your role with the pharmacy?
I'm the owner and the only pharmacist.
Okay, thank you very much. Appreciate you being here today. Mr. McClellan, would you care to make a brief statement before we proceed with questions based on the additional information that Ms. Richardson has provided?
I've had this pharmacy for 26.5 years here in La Paz County, Parker, Arizona. I've done a very good job with my patients. Yes, I've got behind on some things, but I'm trying as hard as I can. I've endured this pandemic for 15 months, and I made myself available for extra hours for my patients on the weekends.
Thank you, Mr. McClellan. Board members, questions for Ms. Richardson or Mr. McClellan?
Madam Chair.
Go ahead, Mr. Dang.
So, Mr. McClellan, you just mentioned about the COVID pandemic. COVID pandemic did not really start until early 2020. Looking at the photos here that are dated back in 2017, the pharmacy is very disorganized. How do you explain that?
Yes, I agree to that. I bought this building in 1998. It's a former Wells Fargo bank building, and it had a lot of square footage, and I took advantage of it by storing a lot of stuff in here. And I definitely put too much in the way of the pharmacy area, prescription area.
Yeah.
And to me, when you look at the photos of the pharmacy, the storage area is one thing even. I still have concerns with the potential for infestation, but when you look at the pictures of what appear to be the filling counter and the verification area, I have very serious concerns about the ability to fill prescriptions safely in this environment. Not to mention the fact that like I said, I think there is the potential for an infestation as well. And perhaps Mr. McClellan isn't even aware of it. These issues do go back to 2016. I tend to believe perhaps he didn't take those violations very seriously. Something as basic as a clean, neat, and organized pharmacy. This is extreme in my opinion.
Madam Chair, may I ask a procedural question?
Yes.
I just want to clarify, is there two issues in front of us? One is the complaint that deals with filling the prescription early. The other issue is the several violations that our inspectors noted on this inspection. Are we lumping these together as one issue, or are we going to treat them as two separate issues?
I think Ms. Walmsley's frozen, at least on my screen. But I can say that I think they're going to be lumped together because it was all part of the same complaint. It's what we found when we asked board to go back and inspect. Oh, there, you're back, Ms. Walmsley. Anyway, can board staff speak to that, just so we have clarification of what I said is correct?
That was my understanding as well. I think I would refer to Jean possibly to make sure that that's permissible.
And I'm sorry, I had to step away to take a call from a respondent in a matter tomorrow. But you have the underlying conduct about whether the refill was provided too early, and then you have the subsequent follow-up with the inspection and what that revealed. So it is all part of the same complaint, and you can discuss the facts separately but adjudicate it together, if that makes sense.
Yeah, thank you. I just want to make sure. Okay, thank you.
Yes.
I have a suggestion. My thought is that we put Mr. McClellan on probation, and the terms of the probation would include a professional company that does cleaning and consults on the policies and procedures, because that's tied into the cleaning as well. I would think maybe a year of a professional cleaning company and consulting company to be overseeing the pharmacy during that time. And then a fine maybe as well as repeat inspection at his cost in a year.
Ms. Snare, when you refer to a professional cleaning company and a consultant on policy and procedure, do you envision that as one organization?
Yes.
And there are organizations, I'm just not familiar with organizations out there that would specialize in both of those areas.
Mr. Gandhi.
Madam Chair and board members, there are organizations that help you structure a pharmacy, help you write policy procedures, SOPs. And then of course they'll submit a full report to the board on the progression and the outcome at the end of the day and what that pharmacy looks like, as well as with pictures and stuff. So we can get that full report on where that pharmacy is and where it moved to. But yes, there are companies out there that it's consultation companies more so than cleaning companies.
All right. And just so I'm understanding what you're moving, and a civil penalty in what amount?
I have questions still for,
I'm just throwing out a suggestion.
Okay.
Go ahead, Mr. Leba.
Mr. McClellan, so these items were of the second inspection, the cleanliness and the policy and procedure, those were repeat, and it seemed like 3 times. And then from the last meeting, you knew we were coming as well. So how come in between that time, you didn't do a massive cleanup? I mean, it is, it's pretty impressive, the amount of stuff that you have cluttered in there. And I don't understand why you need it. There's old phones, there's just a lot of stuff that I don't understand. How come you didn't just clean it up? What's going on there?
I've started to clean it now. I've taken several loads out. I'm 73 years old. I've had 2 heart surgeries. My wife died a year and a half ago. And I've run this pharmacy for at least 10 years by myself because good help's hard to find. Plus, you can't afford it with the reimbursement rates that these insurance companies are paying, and the dispensing fees are so low.
Sure, I understand. I'm sorry to hear that. So, when you look at that though, this goes back how many years, Ms. Richardson? Does it go back 3 years?
2016.
Correct. 2016, I believe, was the first violation. 2017 was the most recent violation, I believe, since it could have been 2018. But yes, it goes back to 2016.
I just think that, in that period of time, you could have cleaned up and you could have got a standard operating procedure.
Okay, I have purchased from a place called Bula, B-U-L-A Law in Scottsdale, a pharmacy policy and procedures manual template, 400 pages. And we've started to go through that, and you can customize it to my pharmacy and edit it. And I have a friend that's a recording secretary, and she's helping me type the stuff into it. So we have started on that part of it.
Madam Chair, can I ask a question?
Yes, go ahead, Mr. Minkus.
Mr. McClellan, how big is this building?
I'd say about 3,000 square feet.
And how much of it do you really use for pharmacy, and how much do you use for what appears to be storage?
I don't know. I'm not good at calculating square feet.
Well, but is it half pharmacy, half? Because what it looks like to me is like the storage, yet you're using it as a storage building, and then everything is kind of just filtering over into the pharmacy, which is making everything appear to be
right. I agree with you.
Out of control. I mean, that's what it looks like to me.
I agree with you.
Okay, and so rather than do a fine, I mean, the probation thing is fine. I have no problem with that. But it seems to me, rather than doing a fine or something with him, it would be better to say, here's the amount of money that we could fine you, but if you'll spend that money and get this thing up to speed and get it where it should be, that would be money better spent, and you'd still be able to serve your community. Does that appeal to you at all?
Yes, it does.
I would be in support of that, but I would also like to see, in terms of just to ensure that it is safe to practice, I have significant concerns. I mean, this is probably this is one of the messiest pharmacies I've ever seen. Perhaps having a follow-up inspection in 3 months, 6 months, 30 days, I don't know the right time frame at Mr. McClellan's expense, since there's going to be travel and additional cost to our inspectors to make sure that this really truly does get cleaned up. I don't know what that appropriate time frame is, but I would be in support of probation. And then with the additional terms that Ms. Snare mentioned around having somebody address the overall conditions and compliance as kind of an independent consultant with it, and then tied to a probation.
And CE regarding the other issue at hand. Ms. Walmsley.
I would be supportive of that related to corresponding responsibility. While there didn't appear to be any massive trends, based on our prior conversation, I feel like Mr. McClellan could certainly benefit from some additional education related to red flags, corresponding responsibility, given everything that's going on with the opioid crisis.
So can we summarize that? I'll make a motion, and if I misstep, you guys correct me. My motion would be probation for a year, and during that time, the conditions would be that a professional company that would have oversight of the cleanliness and the policy and procedures that would report it to the board be employed by Mr. McClellan, and there be a repeat inspection done within, did we say a time 90 days? Is that too far out? What is the comfort level there? Anybody wanna?
So I think it has to be at least 90 days or even possibly a little bit. He's got to find somebody to be able to do this too. And then they got to start the cleaning process, which to me looks like it's going to take some time.
Yeah, it's true.
And if he starts to move in the correct direction, then I think we'd all be fine with it. It looks like he just has said, okay, I'll do something. He doesn't do anything. He needs to be motivated to say, this is for real. If you want to keep this thing, you got to do something. You know, with motivation, people can get a lot of things done.
So this is Goodman with a question for the board. If we're concerned about patient safety, I get there's also the balance of patient safety if this pharmacist wasn't practicing today, you know, just given the market and everything. Nevertheless, if we're concerned about safety, how is it that we could put off action, give him 90 days, things of that nature? Aren't we worried today for patients today?
Mr. Goodman, I struggled with that too, exactly what you said. And I have in my notes 14 days to get it cleaned up. But having heard what's going on today and hearing from Mr. Minkus as well, and Mr. McClellan, it has been operating for a period of time like this. I think 90 days is too long. It bothers me as well. I think if you walked into a situation like this, you may shut down and do a massive rehaul cleanup operationally and then open back up because it's pretty bad. Where I don't know the extent of the messiness is some of those pictures, are those in areas that are non-dispensing period, and that's the storage we're talking about? Or
I think it's both.
And were those the really messy part? And then was the dispensing part less messy where it could show cleanup within 14 days and the storage part within the 90 days?
That's kind of where my head was. I think 90 days is way too long, especially for the pharmacy areas. I mean, if you look at the picture on page 2902, that appears to be what looks like it should be a filling counter. If you look at the picture on page, let me go back, 2897, that looks like what appears to be a verification terminal. At a minimum, to me, the places where you would expect it to be in very neat and organized condition in terms of, you know, making sure that errors aren't made. At the very least, I think that the fulfillment area needs to be cleaned up. I would be acceptable to think that, you know, a stock room or something like that perhaps could take a little bit more time, but looking at the pictures of the filling counter and the verification area are extremely concerning to me today. I don't know how a pharmacist could safely practice in that environment.
I agree.
May I ask, Mr. McClellan, Madam President, how many patients do you take care of each day? How busy are you, Mr. McClellan?
Sometimes on a Monday, I'll fill up to 60 prescriptions. Other days, well, especially going into summer right now, around 30.
And so people come into the pharmacy. You don't do delivery. You don't do any of that.
I've done a few special deliveries in extreme cases, but I don't have
to pharmacy. They come into your pharmacy.
Right.
They see everything, see how it's laid out.
Right.
And you're trying to fill the prescriptions in the midst of all this. Okay, thank you.
Board members, additional questions for Mr. McClellan or discussion? Kristen, were you going someplace different with it?
I was just gonna say, so we think maybe 2 weeks for cleanup in the front, or 1 week to get cleanup in the front of the pharmacy, and 90 days in the storage areas.
I don't have a problem with that. I think he should get the pharmacy part of it under control and cleaned up and operating the way it should be. And the rest of it, he just needs to find somebody, friends, a company, whatever, to start. What appears like to me, most of that stuff is to be thrown away. And it's like, I mean, I'm guilty of it too. I've saved things that you turn around and you say, why did you? And I just went through this with my mom, you know, passing away and cleaning out her house and stuff. So it looked very similar to some of those other rooms. So I understand it. But I think the key is the pharmacy has to get cleaned up first and ready to go. Then let's get the rest of it done in the next 60 or 90 days. And then hopefully it should be good to go.
Yeah, my thought is it needs to be a professional company, not a friend who has expertise in, you know, if it's a rodent or mold or something. And that way we have some accountability as well.
I'm concerned about finding a professional consulting company that's actually, I don't think they're going to actually assist with the cleanup is my concern.
I don't either. I think that's his responsibility.
Yeah.
I think what we can do is we can say, this has gone on since 2016, a combination of this, 3 violations, and then it coming to this here, he's not showing the ability to be regulated the way that we normally would like. Therefore, we could say, you need to have a kind of like a, you know, we have compounding troubles. We have a compounding consultant group come in and do an evaluation and offer recommendations, and we see if the permit holder has followed those recommendations. That's where I see the utility of the consultant, not as much as doing the physical cleanup.
Okay. I am kind of concerned then of maybe some kind of expertise and not just a friend then to speak to more of who would be knowledgeable on environmental hazard or insects. Maybe just he can report to us what he did to clean that up.
Well, I mean, if we authorize that the inspectors need to go out at his cost, the inspectors could go out in 30 days. And if the filling area is not considered clean enough to our standards to at least meet minimum standards, we could take action through, you know, an emergency hearing to you know, suspend the permit. I mean, that's pretty extreme action, but if there's findings of, you know, infestation or mold or something like that in that area, and it's not at least started to be cleaned up, but as he starts to make his way through the clutter, I think we can certainly do that. And I see perhaps our inspectors having to make several trips there in the next, you know, 6 months to a year to ensure that this place really is truly in the right condition. I mean, not in the filling area, but it looks like some of these very boxes and stacks of things on desks are the same pictures from 2017 to 2021. So this is going to be a big project, but at a minimum, I do not feel good with allowing it to continue to operate at least in the pharmacy area in the state.
Yeah, this is Goodman. I concur. We need to focus on the outcome, not how he gets there. If he gets 12 people from the local community center that volunteer and help and it works and they get the right results, great for us. If he hires a firm out of California, great for us. Whatever it does to get to the end.
100% agreed.
Do you want me to try to finish?
Yes, take another shot, please.
All right. Okay, so probation for 1 year, hiring a company to consult with the pharmacy with the policies and procedures and just overall consultation of the pharmacy. And that reports to the board, their findings. Follow-up inspection to be repeated, to be done. I don't know what time frame, but as soon as the inspectors are available to do 90 days, I guess.
No, it has to be within 14 days.
But the follow-up inspection,
I think the follow-up inspection needs to occur after 14 days, the soonest that the inspectors are available, to make sure that the filling areas is in.
so as soon as possible. Okay, so 14 days to get the pharmacy portion cleaned and ready for a follow-up inspection, 90 days to get the storage areas cleaned, and 6 CEs in red flags and corresponding responsibility, in addition to what's required to be done within 90 days.
I have a suggestion or thoughts. I think we should have 2 follow-up inspections, one on day 14 and another one on day 90. So day 14, our compliance officer should be there to make sure that the dispensing area is all cleaned, the temperature in the fridge and everything is all set up correctly, and then come back after 90 days for a second follow-up checkup on this pharmacy. At the open expense.
Oh, so his cost?
Yeah, at his cost.
At his own expense. And also about the probation. For 1 year probation, I don't think that's necessary, because let's say if he's complying with what we ask him to do, is he still on probation for a year?
Well, I don't want him to slide back. I want a year of like, we see continual progress.
He can always come to the board and seek termination, say after 9 months if things are going well.
Okay.
We've typically done probation too, I believe, with similar type items in the past. I can think of a couple compounding pharmacies that had issues with the compounding area and things like that. And I think we put them on actually a 2-year probation.
Okay. So that's all I have. Thank you.
May I ask a question?
Yes, go ahead.
I agree with the first inspection in 14 days to make sure the dispensing area is clear. In lieu of a second inspection for the policies and procedures, would it be acceptable if he submits electronic copies of those so our inspectors don't have to go out there and he doesn't have to pay the expense of our second inspection for those procedural things that can be done electronically?
It's not just for the policies and procedures, it's for cleaning up the rest of the pharmacy. The 14 days is for the pharmacy area. The others for the back stock and offices and everything else that has to be cleaned up. Which is like the more likely to have a infestation if there is one, in my opinion.
Yep. Is that your motion, Kristen?
Yeah, that was my motion.
I second that. That was a lengthy motion.
I know, it took a while to get there.
Can we restate it just to be clear for the group?
I'll try.
Twist and turn.
I have it. Okay.
Okay, thank you, Jean.
It's a one probation that he is to hire a consulting company that will work with him in establishing the operation of the pharmacy, including policies and procedures, that there will be a reinspection in 14 days from the issuance of this order, where we will go up and inspect the pharmacy portion, the dispensing portion of the pharmacy, to ensure that it is clean and well organized. 90 days, there will be another inspection to ensure that the rest of the building, the storage area, has been cleared and is in order. Within 90 days of the issuance of this order, he has to take CE that is in addition to his CE that he takes for renewal in corresponding responsibilities and red flags and prescribing. And I think that is it.
Did you have the probation?
Yeah, 1 year probation.
Okay.
One last thing, Melvin, what if he is in compliance with all the things that we've asked?
That's implied that he can request early termination, but we can state it clearly. Say early termination, what, after 9 months? If he remains in compliance?
I say,
I think he needs, what happens if he doesn't
do it?
In 14 days, we inspect and it's still a mess, then what?
We have to call an emergency meeting, declare it a hazard to the public, and possibly summarily suspend the license permit at that time.
fair enough.
So we'll cross that bridge once we'll get to it, and all we can do is, if he wants it, he'll do it, right? So.
Right.
And this is not a new problem either, so.
Correct. Madam Chair, did you want me to take roll?
Is there any further discussion, board members? Go ahead, Dr. Gandhi.
Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leba?
Aye.
Ms. Lehan?
Aye.
Was that an aye? I'm sorry.
Yes, aye.
Okay, Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Yes.
Ms. Nair?
Aye.
Ayes have it, Madam Chair.
Thank you, Dr. Gandhi. Mr. Goodman, I'm sorry, not Mr. Goodman. Mr. McClellan, thank you for your attendance today in the meeting. The board staff will be in contact with you with the consent agreement and what's expected of you next. Appreciate it.
All right, thank you very much.
Item 25C, Glendale Pharmacy. This was tied to the item earlier in the agenda. We did receive a request that I accepted to postpone this item till the July meeting due to the attorney counsel issue. So we will move back up in the agenda. Mr. Bozen, are you present with us? And is your client present? Can't hear you,
Yes,
Mark.
I'm present, and so is Mr. Hayes.
Thank you very much. So this is item 4AB, complaint number 21-0143. Again, for the record, the licensee disclosed disciplinary action by a professional board in another state. I believe we had some questions potentially for is it Mr. Hayes or Mr. Neal?
Hayes.
Hayes, okay, thank you. I believe we had some questions for Mr. Hayes of a confidential HIPAA nature. Is that correct, board members? If that's the case, I would make a motion to go into executive session for the purposes of HIPAA information.
Do you also want to include legal advice in case we need it?
Yes, thank you.
A second.
All those in favor?
Aye.
Aye.
Any opposed? Mr. Hayes, Mr. Bozen, will be moving into executive session so that we can have a private conversation with you.
Thank you.
Thank you.
Dr. Gandhi, do we have everyone?
Yes, they should all be back, Madam Chair.
Okay. Given that it's almost 2:30, I think most of us need probably just a quick bio break. Let's take 10 minutes and then we will reconvene with discussion on this matter. Welcome back. Dr. Gandhi, do we have everyone?
Madam Chair, I'll take roll call.
Thank you.
Mr. Solari,
Ready, sir.
Mr. Dang,
I'm here.
Mr. Minkus,
Here.
Mr. Leba,
Here.
Ms. Lehan,
Present.
Ms. Walmsley,
Here.
Mr. Tong,
Here.
Mr. Goodman,
Virtually present.
and Ms. Snare.
Here.
Thank you. All present, Madam Chair.
Thank you, Dr. Gandhi. So for the record, we are still on complaint number 4AB 21-0143. We just returned from executive session for the purposes of legal advice following the HIPAA discussions. Are there any other questions for the respondent or his counsel, or any additional discussion as we consider a potential, as we move towards considering a potential motion?
I have a question for Ms. Fine, if she's available.
Go ahead, Kristen. Ms. Fine, are you available?
Yes.
What type of contracts does PAPA offer? What different types of contracts do they offer?
So based on the new contract that we have, or fairly new, with the Board of Pharmacy, we can do substance use monitoring contracts, psychiatric, or dual.
And what would be the difference between the two if they're separate, not the combined?
So the difference would be the substance use one is geared towards those participants with substance use disorders. So it encompasses more urine screens, peer support with our counselors, and then their support meetings are different. So they're the 12-step meetings, whereas with our psychiatric monitoring, they have different support groups. So there's different ones that are focused towards mental illness that are support groups that we would still require them to do. We would be monitoring that they're visiting their therapist and their psychiatrist, and that they're being compliant with their visits and medications. That's a general rule. Now we can incorporate other parameters in there based upon the evaluation and or elements that the board would want to see in there.
Ms. Fine, do you work only with your psychiatric providers in that case, or would you work with other psychiatric providers in case an individual is already under their care?
Yes, so we work with the only psychiatric provider we have is our evaluator, who we contract with, and then we would work with whatever providers that participant has. So we would get monthly counseling reports from them, which is similar to our substance use participants as well, that would go through their progress, compliance, how many sessions did they have with that particular person. They also log and track all of their support group meetings in our database. And they also would be selected for random UAs just to make sure that there's nothing else contributing to the factors. They wouldn't have quite as many as our substance use, but there would be a minimum number of UAs that they would still have to be reporting for.
This is Goodman. On the UAs, they would be the same requirements, though, of responsiveness, just less often.
Correct.
Thank you.
Thank you, Ms. Fine. Board members, any additional questions? All right, hearing none, are we ready to begin to start to try and formulate a motion here? Does anyone have suggestions?
Chair.
Not a motion, but I'd like to address it in a part. And I think the first part would be to extend. I would like to see the contract monitored, and the board have the ability to have tracking and monitoring on that as well. So a consent agreement with the board. And then I would like to extend the, and I think it is, but I would like the ED, Deputy Director at AAG, to work with Ms. Fine and just ensure that we're on the right type of a plan that we need to be on. And then after that, a 5-year probation, continue terms that are chosen in that plan. And it could be that they're on the right one. I just don't know. I would just like them to look at it together. That's the first part. The second part that I think needs to be addressed is revocation in Nevada and coming to work here, if anything does need to be addressed there. And I'm not 100% sure where to go in that direction, but I would like that to see that first part.
I have a question for Ms. Galvin. If we were to move to a hearing, would we need to state a reason for, would it be like for revocation? Would we be able to decide at that time if we wanted to continue with monitoring, or, could we make the decision at that time, or do we need to state the purpose for the hearing at this time?
Referral to a formal hearing is reserved typically for suspension or revocation of a license. If you go to a conference, you can impose or order discipline less than suspension or revocation. So if you believe that a case does not warrant suspension or revocation, moving to a conference would probably make the most sense, unless you can negotiate a consent agreement that is agreeable to both parties.
And Ms. Gowen, that's kind of my point. I feel like I understand. I feel like Mr. Hayes has given us a picture, and I feel like I understand. That's why I say I would like the board to be able to monitor that contract. That's just conversation, and that is my opinion, board members.
And that's a contract that would be ordered by the board, is what I'm hearing?
Yes.
Okay.
Yes. And I'm looking for advice on the appropriateness of the type. And that's where I say, could we work together as board counsel, Mr. Hayes legal counsel, and come up with, do we have the right type of an agreement that's being monitored? And again, we may, I just want to make sure.
Yes, we can always enter into settlement negotiations. You mentioned a 5-year probation. So as part of those settlement negotiations, I would like to be informed of what types of terms you would like to see.
Follow the rules of the contract that's chosen and rules and regulations in Arizona.
May I add a couple of things to that? I would like to see some kind of a thing in there where he notifies his employer immediately. I think we do need to take, since the Nevada board took some actions against him, we need to consider that and see if there is something we can do also. I am more in favor of certain hours of community service, the same way that they do with the substance abuse route, kind of in Arizona, just to take some action against him for doing what he did in Nevada. So in notification of the employer, community service, I think the other contract, substance abuse, has 80 hours of community service or something to that nature. A year for the 5 years, I think that's reasonable as well, just to add to these.
Yeah, this is Goodman here. I've got real issue with penalizing him for actions in Nevada if he's already been held accountable there. Our goal is patient safety. If the community service and items like that help for patient safety, go for it. But it's not our responsibility to go and add a penalty for past actions.
The concern that I have with that statement, Mr. Goodman, is his license was revoked in the other state, and he's not eligible for a reinstatement for a period of 2 years. So he's not currently able to work in Nevada.
Sure. So he is being held accountable in Nevada and not an attorney anywhere close. There's plenty in the meeting. But I think we only get to be prosecuted one time, and that, you know, and this is different than a prosecution, but as far as our accountability, let's hold it to the safety and licensing here and any actions here, not, hey, this is what you owe us to show, you know, to as a penalty.
That's kind of where I was going with the probation, Mr. Goodman, to your point.
My thought, Mr. Goodman, is that the same person that did those actions is coming to work in our state. It's not that they're necessarily penalized, but for the same reasons they were concerned would be the same reasons we would be concerned. And if they had that concern over patient safety in their state, I would also have concern over patient safety in ours. So I would like to see a hearing.
Oh, I have great concern over patient safety. I have some real issues and concerns about it, inconsistencies, things of that nature. Where my concern is with the statement of saying we are going to now have him do community service as some type of a penalty, that's not our place.
Oh, I see.
Just
Okay.
so for the board's education, because we do have some new members, your statutes define what constitutes unprofessional conduct. The board is authorized by statute to discipline someone who has engaged in unprofessional conduct. Your statutes define for a pharmacist unprofessional conduct as having the licensee's license to practice pharmacy denied or disciplined in another jurisdiction. So it's up to the board, but they do have the authority, Mr. Goodman, to discipline someone for being disciplined in another state.
As our action, but not as some action of what happened there. So
Yeah.
I get where you're going, but it's a nuance, but I have concern with the statement. So thank you.
Yeah, I would like to see a hearing. I just think that, to me, possible revocation, a medical history is one thing, and diverting items is another thing. So
I agree.
Sarah, so if you look at some of the cases that come before us, they have been of the nature of controlled substances that we're involved in practicing today in Arizona. That's why I'm not for the revocation. I am for the monitoring, probation, and keeping an eye on it.
I think we have done some things, and if you look at technicians, I would say we've revoked so many that have diverted without really any thought. And I feel like it wasn't a substance use situation here.
It wasn't, and the nature of what was diverted was not as serious as what we've seen from this court before, and we've not revoked.
He also has been evaluated by a professional of our choice that we use anyway, and that individual sought for him to be fit to work. So I'm not sure if revocation would be appropriate. I generally tend to agree with Mr. Leyba. I'd like to see some terms that we put in place so that we can monitor him for the 5 years and make sure he's doing okay and the patients are doing okay. I understand your point of view, Ms. Snare and Mr. Goodman. I'm not sure if that'll do any good. Anyway.
Yeah, this is Goodman. A revocation, hearing for revocation isn't a decision now to revoke, right? It's to have the discussion and see all the facts. So we don't have to decide right now if he is fully needing to have his license taken. We can just decide that we'll have the hearing where it could happen.
Correct.
Okay.
What are we going to learn from the hearing different than we are learning today? Or is it just the purpose of the procedural pieces that need to happen from an administrative procedures?
That's why I'm kind of against going to the hearing. I'm not sure what we learned from it that we haven't already. It would be a lot of work for councils on both sides just to present the existing facts to us in some exhibited manner. But I don't know that I'll learn anything new from it.
Well, I would want maybe to address some of the inconsistencies and statements that we've heard today.
I'm with Mo. I don't think a hearing's gonna do anything. I'm opposed to that.
I mean, if you look at it from an evidence standpoint, there is inconsistencies, but on neither side, there's substantial evidence. It's basically hearsay. This person said one thing, we saw another. I don't know what is it the best use of our time to go to hearing? I don't know about that.
Do you feel like the inconsistencies, if they were cleared up, would change someone's evaluation? I mean, I guess that's just asking you to guess, but.
At this point, if you want to clarify the inconsistencies, we can go back into executive session and confront those. I'm not sure what we'd learn from it. I don't know that we need a hearing just to clear up inconsistencies. If you want another evaluation by another professional, we can also order that now. We don't need to go into hearing for that. I just don't see the value of spending the time and energy to go into hearing to rehash the same stuff we already know.
But if we're depending on an evaluation that may have inconsistencies, it might not be the best thing to depend on.
I mean, thinking back, we've had evaluations by two different professionals that reached two different conclusions. I think Mr. Boson was the attorney on that case as well, where one professional said one thing, a different professional said another thing. Then we had to go to a third professional. Things dragged on and on and on. And again, the individual's back working in that case as well. So I don't know.
That's a good point.
At this point, I think it's just best to go forward, in my opinion, best to go forward with the foundation that Mr. Leyva put in place and sort of expand on that and come up with some agreement where we can be safe and he can be safe and our patients can be safe and go forward from there.
So, Madam Chair, I'll begin a motion. So I would make a motion to enable the board staff to work with legal counsel, Mr. Hayes, and Ms. Fine to confirm that there is an appropriate monitoring program in place tied with a 5-year contract of probation and notification to a current employer. And then after that, come back to the board and say we do have the correct monitoring program in place. This is a program that covers the bases that we discussed today.
And that would be a monitoring program ordered by the board.
Yes, ma'am.
And a reciprocal employer notification, and then the employer notifying the board that they are in receipt of the consent agreement.
Yes.
Their probation tied to it?
Probation, yes. 5 years.
And I'm understanding that you want this agreement drafted and then reviewed at the next meeting?
Well, I think you and board staff have a picture of what we want. I think that, and this is my opinion, that if we can get there with Mr. Hayes' counsel and define that we can move forward, it can appear on the consent at the next meeting.
So that next meeting, Cam, help me, is that in June or July? We have
July.
So then there's nothing in place between now and July. Okay.
What's in place is on record saying that Mr. Boson has said that he's signed a waiver and Kelly Fine and would notify the board if.
And that was an executive session, so I would prefer that that not be disclosed. I believe that was an executive session.
It was, Madam Chair. Or, I'm sorry, Jean.
So we will negotiate something and then bring it back to the board in July.
Jean, can you restate the motion? please.
That the board authorize board staff, the assistant AAGs, Mr. Hayes and his attorney, Mr. Boson, to enter into settlement negotiations for a 5-year monitoring contract that is appropriate with PAPA, that there be a notification provision that if entered into, Mr. Hayes is required to notify his employer of the existence of the contract, and that this would be drafted and meet the staff and Mr. Boson and Mr. Hayes' expectations, and back to the board in July for approval.
Second.
Thank you. I have a motion and a second. Any further discussion?
This is Jennifer. I have a question.
Yes.
Since this is a contract involving probation, I'm wondering if the board members have any opinions on his ability to be a PIC or preceptor.
Oh, I didn't hear the last part.
His ability to be a PIC or a preceptor.
I think that is typically one of the standard terms.
Yeah, I agree. And he should not be a PIC or a preceptor during the period of probation. And that is standard. We've always done that.
And since this is just a motion to negotiate, you do not need a roll call.
Thank you, Ms. Galvin. So any further discussion? All those in favor?
Aye.
Aye. Any opposed?
Nay.
So it sounds like one nay, the rest were ayes. Motion carries. Thank you both for your time and attendance today. Mr. Hayes, I appreciate you making yourself available at the last minute today.
Thank you.
Appreciate it.
Thank you, Madam Chair.
All right. Dr. Gandhi, can you direct me where you think we should go next in the agenda? I know we had a couple of items from this morning. Were we able to get a hold of any of those individuals?
We were Allergy Partners Therapeutics should be on the line.
Okay, that is item 13A.
I believe Ms. Short, Kelly Short should be present.
So Allergy Partners, this is a non-resident pharmacy permit requiring board review. Who was the compliance officer on this one? Mr. Hyber?
That was me, yes.
Mr. Hyber, can you give just a brief recap for us?
Sure. This application was turned in, and we found that one of the officers was listed was a practitioner. We obtained a statement from that individual in order to allow the permit to proceed by disclosing that they would not, that they wouldn't issue prescriptions that would be filled at any of these locations. We subsequently discovered that some of the other owners were not disclosed as practitioners. We found that by just basically looking at the name and looking at the location where they have their address of record, and we found that without any exceptions, everyone we checked turned out to be some type of practitioner. So that's at that point we decided to send this application forward for review.
Thank you, Mr. Hyber. Who do we have on the line from Allergy Partners?
Kelly Short.
Thank you, Ms. Short. What is your position with Allergy Partners?
I am the pharmacist in charge for Allergy Partners Therapeutics.
Thank you very much. Do you care to make a brief statement before we proceed with questions, hearing Mr. Hyber's concerns?
A brief statement. The application is put in on behalf of Allergy Partners PLLC, and the Allergy Partners Therapeutics is doing business as Allergy Partners PLLC. And I'm happy to answer any questions that the board might have in that regard.
Thank you, Ms. Short. I guess to kick off the discussion, Our Arizona statutes prohibit a prescriber from owning a pharmacy if they receive any financial compensation for prescriptions that are written for themselves. Can you explain your business practices and if you fill prescriptions written by the owners of this pharmacy?
We are affiliated with the Allergy Partners PLLC. We do fill specialty pharmacy medications on prescription. I'm not sure if I heard you correctly. They are not filled for any family member or staff member. They are patients of the practice.
So you do fill prescriptions, just to clarify, that are written by the prescriber owners?
Yes.
So that is in conflict with our statute.
Okay. My understanding was that for the application, there was a question about the ownership of the pharmacy as having more than 5% ownership, and there is no individual practitioner that owns more than 5% in the company.
Sure, that's a law for another state. Our state statute says a prescriber cannot, that prescription written by that prescriber cannot be filled by the pharmacy they own. Doesn't matter what percent they have.
Okay.
Are these the only prescriptions that you fill at your pharmacy as prescriptions written by the owners?
At this particular time, we are a brand new pharmacy, so we are reaching out to build patient volume, and it's something that we look to do possibly in the future. But for now, it would be providers that are part of the Allergy Partners PLLC. I was not aware of that particular statute. So.
Given this information, looking for some direction from the staff, I don't think at this point we have the ability to issue a permit based on our statute.
Madam Chair, I think the only issue we had was that I think the only option we could offer would be to allow them to withdraw, because I don't believe there's any other concerns other than that right now.
I think that's fair because a lot of people don't know that, and there isn't anything that is other of concern or safety, in my opinion here.
Agreed.
So if we denied it, there's different ramifications to that versus if we said you didn't know, understandable, and withdraw.
Right.
Yeah, they did not try to deceive us. They were upfront with all the information. Let's allow them to withdraw at some point down the road when they grow their business and they can take care of Arizona patients with Arizona prescribers or prescribers that are not part of their ownership team. They can always come back and reapply, and at that point we'll address it.
I agree. I'd second that. Mo.
I'll make that my motion.
So I have a motion and a second. Any further discussion? All those in favor?
Aye.
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 Any opposed? Thank you, Ms. Short, for your attendance today. The staff will be in contact with you.
Yes, and thank you for hearing and for allowing us the opportunity to withdraw. I appreciate that.
Thank you. Appreciate it.
Thank you. Bye.
All right. Dr. Gandhi, items tab 17, is that next?
Yes, Madam Chair, 17A.
Okay.
Arcus Pharma.
Yes, 17A, Arcus Pharma. This is a non-resident non-resident manufacturer, virtual manufacturer permit. Looks like, who was the compliance officer for this case or this application?
Take a look, Madam Chair.
or if you can speak to it. It looks like there was several questions around whether or not they applied for potentially the right type of permit. Should it be a manufacturer permit versus a virtual manufacturer permit? From my notes here.
Yes.
Do we have anybody? Do we have anybody on the line from Arcus?
Yes. Hi. My name is
Hi.
Vivin Lucas.
Hi, Vivin. Can you please state your position with Arcus for the record?
Sure. I'm the Director for Strategic Contracting and Pricing. I oversee the commercial operations for the company.
Thank you. Board members, questions for Mr. Lucas? So I guess my question for you in reviewing the materials is, are you doing actual manufacturing at your facility?
No. So Arches Pharma is a virtual manufacturer. It's a 100% owned subsidiary for RK Pharma company. So we are a virtual manufacturer. We have a 3PL who will be distributing the products in the US. So our own product pipeline, excuse me, our own product pipeline will be taking some time to be launched in the US pending the FDA approval. But for the time being, we have acquired a few products from another company, and that would be the products that we will be distributing in the US. That's actually being manufactured by a CMO.
Madam Chair, if I may.
Yes, go ahead.
Where are those CMOs located?
So it's the products that we are acquired is from Mylan. So they have multiple manufacturing facilities. So it's a bunch of, I think it's a basket of 4 to 5 products. So they have manufacturing facilities in Puerto Rico, in Morgantown, and the others are in India.
Those facilities are FDA registered?
Yes, they are.
CGMP compliant?
Yes, they are. Yes.
Tested?
Yes, yeah. It's Mylan facilities, so they have been around for a very long time.
Where's your 3PL? Madam Chair, I'm sorry.
No, go ahead.
Where's your third-party logistics provider located?
It's RX Crossroads. It's a facility. It's a McKesson company located in Mason, Ohio.
And we did verify CAM. They have a permit with us.
Okay, thank you.
So staff, does that resolve all of our questions regarding this application then? It seems like it does to me.
It does for me. And if the business model changes at all, they would just have to notify us.
Sure.
Board members, any additional questions for Mr. Lucas? If not, I'm comfortable making a motion to approve.
Okay.
All right, hearing a motion and a second, any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes. Thank you, Mr. Lucas. Appreciate your attendance and best of luck to you.
Thanks a lot.
All right, item 17B, Brasseler Medical USA LLC. Dr. Gandhi, I believe that there's a consent agreement that you were working on related to this application. Can you give a brief update for that for the board members, just to make sure that they're all up to date on that?
Certainly, Madam Chair. Brasseler was located in California, and they were permitted with us at one point in time. They let their license lapse, so it was expired, and after the expiration of that license, that permit, they continued to ship into Arizona from California. After 2 months after their permit had expired, they had relocated to Georgia, and again continued to ship into Arizona for a while until we got them, until they submitted this license. In essence, we did discuss the activity with them and determined a fair consent agreement, total fine of $20,000. And upon signing and paying the civil penalty, the board would consider the application and possibly issue a permit. That's all pending your review and your approval of the consent agreement.
Thank you, Dr. Gandhi. Does someone from Brasler want to make a brief statement? Or do we have any questions for Mr. Gandhi or Brasler?
Yeah, this is Rod Rylands. I'm the Director of Quality Assurance and Regulatory Affairs for Brasler. And first off, I want to thank the board for hearing us today. And as Dr. Gandhi said, you know, Brasler had a manufacturing plant. We had our manufacturing plant in California and relocated that to Georgia. And we do recognize that we did make some mistakes and some challenges in maintaining this license throughout that transition. I can say that we've made some changes as a result of that. We've changed some leadership as well, including regulatory personnel, as well as process changes and including internal oversight from our parent company, Henry Schein. I can say that this was not intentional, and we appreciate the board's willingness to hear this and help us resolve this matter in obtaining this new license.
Thank you, appreciate that. Dr. Gandhi, do we have an executed consent agreement? I don't see it in the packet.
We do have a signed copy, Madam Chair. It arrived, again, a little later. Negotiations took a little time, but we do have a signed consent agreement.
Okay.
And it's just the usual terms with a civil penalty component to it.
Okay. Board members, any additional questions?
Would we have to wait for the next board meeting to look at this agreement and approve it?
Again, Madam Chair, Ms. Nair, it's a normal language routine. It's up to you. I mean, I can disseminate it out for your review.
Would we be able to approve it now is, I guess, my question.
Yeah, if you can, that'd be great.
I make a motion to accept the consent agreement.
And approve the permit?
And approve the permit pending the terms.
Second.
I have a motion and a second. Is this roll call since there's discipline with it, Ms. Galvin?
Yes.
Any further discussion? If not, Dr. Gandhi, go ahead with the roll call.
Certainly. Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leva?
Aye.
Sorry, nay or aye?
Aye.
Aye, sorry. Ms. Lehan?
Aye.
Ms. Walmsley?
Aye.
Mr. Tong?
Aye.
Mr. Goodman?
Aye.
Ms. Nair?
Aye.
Ayes
Ayes have it. Thank you very much all for your attendance and for working with staff in the interim between the meeting. Best of luck to you and appreciate your attendance.
Thank you very much.
Thank you.
All right, items 17C and 17D are related. These are owned by the same organization, however, are located in two different states. And looking at the materials, there are many similarities between the two. So this is SCA Pharmaceuticals, one located in Little Rock, Arkansas, the other in Windsor, Connecticut. Dr. Gandhi, do we have the compliance officer on the line that did the review, or can you provide a brief summary?
Yes, Madam Chair, just pulling up the applications.
While we're doing that and pulling that up, do we have anybody on the line for SCA Pharmaceuticals? Ms. Kurtz, if you're speaking, we can't hear you.
My apologies. My name is Megan Kurtz, and I am the pharmacist in charge for the Little Rock location for SCA Pharmaceuticals, and my colleague, Alyssa Johnson, is my counterpart in the Windsor facility.
Thank you very much. Appreciate it. Thank you. Thank you for being in attendance today. Dr. Gandhi.
Madam Chair, I think the concern is outlined. There was a 483 from 2019. They had repeat violations or observations, the same observations from 2017. Environmental controls, concerns with RX labels, not compliant as well, compounding commercial products action taken on 2019 report is still open. 483 responses received and uploaded.
And from my recollection from the reading, there were similar violations from the FDA at both facilities.
That is correct, Madam Chair.
And that was the concern, is that there's some crossover perhaps in corporate policy. Ms. Kurtz, Ms. Johnson, would one of you like to make a brief statement before we proceed with questions for you on Dr. Grundy's concerns?
I'd be happy to start for us. I'd like to start with all of our 483s from both 2017 and 2019 for both sites. All of our responses and our actions and commitments to FDA are complete at this time with full remediation. We are awaiting FDA's closure of both of those inspections, and we expect those to be closed without repeat observations. In regards to the repeat observations, the headings for those observations are the same, and you do find those from 2017 and 2019. But what you'll see upon a little bit closer of a read, the actual 483s are regarding a little bit different subjects each time. One in particular was for the need for further investigation, a deeper dive into some of our issues, specifically related to any unexplained discrepancy. One of those was related to environmental monitoring, and it has been remedied, while the one in 2019 was actually related to a potency testing concerns. Both of those have been remediated at this time. If there are others or specific questions, Alyssa, I'd be happy to answer those.
Thank you. Board members, questions?
Madam Chair, may I?
Yes.
Ms. Kurtz and Ms. Johnson, were you the PICs at the time in 2017 when these observations were made by the FDA, or was that a different PIC?
They were different pharmacists in charge.
So you took the job over knowing that you have to fix these things, and you believe, both of you believe you put what you need in place to make sure these things don't happen again?
I'll speak for myself, but yes, sir, I do.
Yes, I am confident that we have taken the appropriate actions to remedy the observations.
Thank you.
Mm-hmm.
Board members, any additional questions?
Madam Chair, I make a motion to approve 17C and 17.
A second.
Second.
A motion and a second. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Hearing none, motion passes for 17C and 17D. Ms. Kurtz, Ms. Johnson, thank you so much for your attendance and hanging in there with us today. Best of luck to you.
Thank you very much.
All right. Looks like tab 18 is vacant, tab 19 is vacant. Moving on to 20, renewal applications requiring board review. I believe 20A and 20B were related to the items from the complaint committee, for which I'm also recused. I'll take some direction from staff on how we want to take those and turn it over to Ms. Snare to lead the discussions on these next couple items.
Certainly, Madam Chair. So 20A is related to 4Y, the application. So yeah, if we can take them both together, and again, 20B is related to 4AA, so we can hear those together as well.
Okay. So let's start with 4Y. 4Y, a pharmacy technician worked on an expired license. And I just want to make sure real quick, is Claudia, the Quintagon is available?
She is available, Madam Chair.
Okay. Why don't you go ahead and introduce yourself?
My name is Claudia Quintana.
And maybe we just start with some questions. I'll start. So can you tell us about when you worked, how long you worked? We estimate about 70 days, and tell us just some more about that. You worked without a license during that time?
Ms. Snare?
Yeah.
Could I request that we have board staff kind of give us a little bit of background on it? It might help me with the framing in my mind of where we need to go, and then maybe go to, since there's 2 items on this, and then go to the respondent.
Sure.
Sure, I can do that. It's my case. Claudia had a technician trainee license prior to her pharmacy technician license. Once she was issued the pharmacy technician license, the tech trainee license was superseded, so it no longer exists. Her pharmacy technician license expired on October 31st, 2020. She submitted her renewal once it was found out and discovered. And that is what is being dealt with 20A.
Okay. Thank you.
Okay, now, Ms. Quintagon, if you would, please go ahead and speak. That'd be great. Thank you.
Yeah, so I am relatively new to the pharmacy world. I was under the impression that my license would be valid for 2 years. And so when I was fully licensed, it's my fault, I didn't really give it much thought. I turned in all of my paperwork to my supervisor and just kind of went to work and continued to work. And I do see that I got emails. I went back again today and I did find one from October from State Board of Pharmacy, and I have 1,000 excuses and none of them are good enough. If I was in your guys' position, I'm a working mom. I go to school. I get 100 emails a day. It looks like I opened it and then just didn't think about it again. I have no real excuse, and I just kind of hope you guys are lenient.
Thank you. Anybody else have questions or like just to open up discussion? It looks to me, like I said, maybe it was 70 days that she worked without a license, if I'm calculating that correctly.
So that's 70 working days.
Yeah.
Days.
Yeah. Which is what we look at, correct, when we look at the grid.
Mm-hmm. So I would go with the civil penalty that we have. There's a grid of penalty that we have used in the past, and we'll fine her based on that.
So I have a question about that. Do you feel like the permit holder should be held responsible as well?
Yes.
They are listed in the complaint.
Yes.
Curious what the thought is on that. I unfortunately don't have that grid in front of me. So we have a maximum not to exceed a certain amount.
I have it open. For the permit holder, it's $50 per day, not to exceed 1,530 days. The PIC would have to do 3 hours of non-disciplinary CE in law within 90 days in addition to biennial review. And for the technician, it's $30 per day, not to exceed $300 within 180 days.
Yep. Mm-hmm. That's what I have too.
That's in page 63 of the board book.
Thank you. Does anybody have any thoughts that are contrary to that guidance? Or do we want to go ahead and proceed with that as being a motion?
In my opinion, this is pretty straightforward. We're gonna go with that. So I make a motion to impose a fine of $1,500 to the permit holder, to the PIC 3 CE of non-disciplinary in law within 90 days. And to the technician, $30 a day. Well, we're gonna fine her $300 and has to be paid within 180 days.
I'll second that.
The CE was in law.
Yes, in law within 90 days.
Since these are combined with 20A, is the granting of the renewal contingent upon signing and paying the civil penalty?
Yes.
And I'm in my second. Okay, are we ready to vote, or is there any discussion before we vote?
Just got a question. Mr. Hargrave, she can work, produce income during that period of time to pay it off that 180 days.
That's up to you. I think if you're contingent the renewal upon the payment or contingent upon the signing, or you're not contingent on anything. But yeah, it's got to be either way. It would have to be a provision to renew the license.
Seth, would they be able to renew it for a certain time period in order for her to be able to get to pay it? Like they renewed it until today's date for them to address it?
That's up to them.
So she has 180 days to pay. Can we extend it for 180 days, or is that beyond what we're allowed?
One thing that where I was going with it is this was a little bit confusing. There was a violation, and Claudia came forward. She was forthcoming. She didn't make up excuses. She owned it. I do feel that upon signing, she should be able to produce income, and that she should pay that off within 180 days. This one is different than our other ones that are in front of us that they just didn't renew. This one, a license superseded it, and I can see in that perspective how that could happen.
Yeah, so you can have the renewal effective upon signature, and then if it's not paid within that time, then the board can address non-compliance as a separate matter.
I do think that's fair.
I do too. Mr. Dang, do you?
Yes, I concur.
Sorry, Ms. Galvin may have some guidance before we proceed.
I agree with everything that has said. The license has been renewed through today. It's going to take Seth and I a period of time to draft the consent. Does staff have the authority to extend it for like another 2 weeks to give Seth and I a chance to draft the consent?
I would say yes.
Mm-hmm.
Okay. Mr. Dang, do you want to amend your motion to reflect that?
I will amend my motion to reflect what are all the things that Ms. Galvin and Seth had mentioned.
And I will amend my second as well. Okay,
Thank you.
so if no further discussion, we'll go ahead and vote.
We do need a roll.
Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Lebo?
Aye.
Miss Lahan?
Aye.
Ms. Walmsley? Is recused. Mr. Tong?
Aye.
Mr. Goodman?
Aye.
And Ms. Nair?
Aye.
And if Claudia has questions, maybe she could call one of the Jennifers in the next day or two, but your license will be extended for a couple of weeks.
Thank you.
Okay.
Thank you very much.
Thank you.
Okay, we're going to go down to 4AA.
And
Susan.
20B also at the same time, Madam Chair.
I'm sorry, what was that?
4AA and 20B.
And 20B, yes.
Taken together, yes.
For Susan Shipley.
Correct.
And I see she's on. Can we please have a recap from Mr. Wagner? Is he on? Oh, there he is.
Yes, this is a similar situation to the previous case. The technician had a trainee license that expired in March of 2021. And in February of 2021, she came in to renew her license. However, she was issued a technician license I lost that date. July of 2019. So the trainee license was superseded. She is a assistant manager, so she doesn't work in the pharmacy routinely. When I did visit the pharmacy, the technician trainee license was displayed on the wall in the pharmacy with that March expiration date. Going back through their records, she did work in the pharmacy after the expiration of her technician license on December 9th, 15th, 20th, and 24th.
So 4 days total,
Correct.
because she was just a front end manager and fill it in. Okay. Did we lose Miss Shipley? I'm not seeing her on my screen at least. Oh, there she is. Okay. Miss Shipley, would you like to introduce yourself and make a statement?
Hi, thank you again for this opportunity to speak and hearing me. Unfortunately, I did not know about the expiration of my license because I was looking at that March 31st license. And so I just assumed I had until that time. So I did my continuing education CEs. I did apply for my renewal at the end of February, beginning of March, thinking the end of March was my renew date. Unfortunately, that was wrong. And then that's how I'm before you today. I apologize for not keeping up with this. This is all new to me. And I was not a full-time technician at that time. And so just filling in, unfortunately, I did not keep up with my licensing as I should have, because there was 3 that I had to deal with, and I did not realize that one was superseded by the other.
Okay. Board, any questions for Mr. Wagner or for Ms. Shipley? Okay, does anybody want to make a motion? If we're using the grid, it looks like it's $120.
Yeah, if nobody's willing to make a motion, I am, and we can duplicate the terms of the previous one, except that since there was 4 days that she worked as a technician without a license, 4 multiplied by $30 would be $120. Otherwise, all other terms identical to the previous case.
In granting the license, just want to clarify. Yes.
Yeah, everything else is similar, and she was not trying to be deceptive, and she's forthcoming and accepting responsibility, and she deserves to work, and the leniency that we offered the previous case should be extended here as well.
And Mr. Dang had a second. Any discussion before we vote?
To confirm, does this apply to the permit and PIC as well?
Mr. Solari.
I'm sorry, I didn't hear that, Dr. K.
To confirm, does this apply to the permit and the PIC as well?
Yes, the permit, and they are named in the complaint, right?
Yes, they are.
Yeah, so then the same, I'm sorry, you're right. I should clarify, the same $1,500 to the permit and the 3 hours of CE for the PIC.
The $1,500 would be adjusted down though, wouldn't it?
Agreed, yes.
Okay. All right, and we need roll call on that.
Okay. Who was the second, Madam Chair?
Mr. Dang.
That was second, yep. Mm-hmm.
Okay, Mr. Solari?
Aye.
Mr. Dang?
Aye.
Mr. Minkus?
Aye.
Mr. Leyva?
Aye.
Dahan?
Aye.
Ms. Vaughn, please recuse. Mr. Tong?
Aye.
Mr. Goodman?
Aye.
And Ms. Nair?
Aye.
Ayes have it, Madam Chair.
Thank you. All right, item 20C, Judith Clark. I think Ms. Clark is present. Can you state your name for the record, please? We can't hear you if you're speaking.
Judith Clark.
Thank you. Dr. Gundy, which compliance officer had this one?
Madam Chair, this is actually mine.
Okay, if you could give a brief recap, Jennifer.
Sure. So Ms. Clark has been licensed as a pharmacist since 1988. Her license expired on October 31st, 2019. She applied for the renewal of her license on February 25th, 2021. And at the time of her renewal, she was not employed in a pharmacy. In February 2021, Ms. Clark reached out to us regarding the reinstatement of her vaccination certification. Based on her statements and information she provided to staff, there was concern that she was performing pharmacy services through Medical Reserve Corps without an active license or proper authorization. In an email, Ms. Clark stated that she did technician duties. She removed syringes from packaging, assembling, and drew up a dose of Pfizer vaccine. Additionally, she stated that a technician working with her verified the doses that she drew up.
Thank you, Jennifer. Ms. Clark, would you like to make a brief statement about what transpired?
Yes, I don't know if you received, I sent some information in that I would hope that you have copies of. I've sent in 2 comments from people that I've worked with and also a summary of what happened that day. It started when I heard about the epidemic, and you'll have to forgive me, I'm very nervous. I heard announcements that they wanted and needed pharmacist vaccinators who had retired to come back and work. I read in several different things in FEMA, Medscape, PrEP Act, APHA, all saying that pharmacists that had not renewed their license in 5 years were eligible to come back and work and help with the epidemic. I went to the appropriate steps. I went to APHA, I'm sorry, for the Arizona AZESARVHP and put in my application to help, and they approved me. They vetted me through the Arizona Health Department, and I have an email that I had asked why I hadn't been offered any medical positions, and they said that they had not verified me, but she said, thank you for your email. Your credentials weren't verified, but I verified them today, so you should start getting medical missions sent to you. I was checked for
Ms. Clark, do you need a minute? Are you okay?
I'm okay. I'm sorry.
No, that's okay.
So I went through the whole process. I went to the Medical Reserve Corps and signed up. I honestly could not wait to help. I felt like it was very important. And when I went the first day, I brought my expired license. I showed it to the PIC. I showed it to the other people there. I had always put in that I was not currently licensed. Everything I put in, every single form I filled out, everyone I talked to, I told them my license expired because I chose not to renew it. And I was passed through the system. Like I said, the final approval came from the Arizona Health Department. I went in, I did my job that day. I put together syringes. That was basically it. The technician then asked me if I wanted to practice doing a dose of Pfizer, which I did, because that's That's what we do in the pods. You drop the doses, you get the things prepared. I wanted to vaccinate also, so I called the board to find out how I could vaccinate. Again, I was all under the assumption that my license had only expired 1.5 years before, that I fit into that emergency situation that had been all over the news. If you had been less than 5 years, you could go back. And I followed all the procedures. And so then, I'm sorry. So then I was told that I needed to get my license back and that I may have committed a felony. And needless to say, I immediately got my license back. I did my CE, my CPR, I did everything within 5 days. I sent it up to the board and it was delayed for several days. I got my license back, my full license. I've never had anything in front of the board before. I've been to PIC. I worked for almost 30 years. All I wanted to do was help. And I didn't know I
I got
was
a question
doing
for you,
anything
Judy.
wrong.
Judy, I have a question for you. First of all, I want to thank you for stepping up and volunteering when we needed you. So I do appreciate that. What is your interest in getting your license renewal now? Are you wanting to go back and help more at these events?
I have worked, since I got my license back, I've worked 30 shifts, over 150 hours. I have never felt better in my life knowing that I'm helping getting people vaccinated against this horrible disease. My intent is never to go back to work in a retail pharmacy again. I would like to volunteer for FEMA. They've sent me some information, but I couldn't commit to anything because my license wasn't totally taken care of. And so my whole plan is to work as much as I can in this time of need and maybe stay on with the Medical Reserve Corps. I've volunteered before. I volunteered at Katrina. I volunteered during the weapons of mass destruction.
Gotcha. Well, I tell you what, I thank you for that. And you have my support. And I would not be in favor of doing anything else but thanking you and accepting the renewal application.
Thank you.
Is that your motion?
Yes.
I'll second.
Any further discussion? I kind of want to go to an executive session for the purpose of legal advice.
Second.
All those in favor before and then we'll come back for the motion on the floor.
Aye.
Aye.
All right, do we have everybody back? So Ms. Galvin, please remind us of the motion that's on the floor.
The motion on the floor was made by Mr. Leba, seconded by Ms. Snare to accept the renewal application.
Board members, any further discussion on the motion?
Ms. Clark, can I clarify with you, were you ever paid for any of the work you did?
You're
Clark, we can't hear you.
Can you undo your microphone?
I'm so sorry, I'm new at this.
Okay.
No, I've never been paid for any of my work and I have no intention of being paid for any of my work. I'm here as a volunteer only to help with this epidemic.
Thank you, ma'am.
Thank you.
I think that due to the CARE Act provisions that have been updated, that what she was doing is very beneficial, and there was kind of just some mixed wires going on here. So I want to stick with my seconded.
Ms. Snare, do you mean the PrEP Act, not the CARE Act?
Thank you. Yes.
Okay, thank you.
I don't want to change my motion.
All right, all those in favor?
Aye.
Aye. Any opposed?
Nay.
Motion carries. Thank you, Ms. Clark, for your attendance today and for hanging in there. I know it's been a long day, and thank you for your service to Arizona.
Thank you.
Thank you.
Tab 21 is vacant. Tab 22 is vacant. Can we take 23 today, Dr. Gandhi? Or Jennifer?
Okay with taking 23.
Amy Mefford.
Yes.
I'm sorry, I couldn't understand you.
Oh, I'm sorry. Yeah, yes, that's correct. 23A.
Okay. Do we know if she's present?
I have not seen her present. I don't see her in the meeting.
So this is a technician license requiring board review. It looks like Jennifer, this was yours. Can you give a brief summary to the board members?
Sure. So back in February, and this is just for the record related to complaints for the.
You're breaking up.
This is related to complaints 4V and 4W. Can you guys hear me okay?
Yes.
Yes.
Okay, good. Okay. So back in February, I was contacted by Banner's recruiting department. They informed me that Ms. Mefford had been working at one of their medical centers on an NABP passport. At that time, Ms. Mefford did not have an emergency authorization to work or a pharmacy technician license issued by this board. And so I would refer you back to the two complaints that were already reviewed. So the following day, I informed Banner that Ms. Mefford did, in addition to an NABP passport, need an emergency authorization to work or a valid license in the state of Arizona in order to practice pharmacy. And at that time, my understanding is that Banner removed her from the schedule until she was issued an emergency authorization to work.
Thank you, Jennifer. So roughly how many days did she work without a license? She did not practice. She did not practice without a license.
I'm going to just go back to those complaints very quickly. A moment, please.
In the third paragraph here, it says Banner Health was responsible for ensuring that Ms. Mefford did not practice while she was issued a valid license per the board.
I believe it was approximately 12 days.
Oh, it was 12 days. Okay. And Ms. Mefford is not present.
No, not that I see.
Okay. Board members discussion.
What was that? I cannot remember. Help me out here. Was this training that was the shadowing that she did, or what was this that 12 days?
I think that was a different case.
Carol, would you like to speak to that timeline?
Absolutely.
Thank
There
you.
have been to date 3 cases that have come in front of this board for essentially the same issue with this NABP passport. So the case that you're referring to, Mr. Leyba, is a different case. In Ms. Mefford's case, she, after her training, did work for, I believe it was 12 days on the schedule until Banner realized their error and took her off the schedule. Or actually, they didn't take her off the schedule. They made her a runner. She wasn't doing pharmacy duties. I should correct that.
And
she was or was not? Repeat that again, Carol.
She did work for, I believe it was 12 days And then she was made a runner rather than performing pharmacy duties.
So she practiced as a technician for 12 days without a license.
Correct.
Okay.
And Ms. Kinnevong, you had told them, I just want to confirm that, you had told them that she couldn't, and then the 12 days took place, or had you told them that she couldn't while it was going on?
My communication to Banner occurred, it would have been after the 12 days. So the day that I contacted Banner, they removed her from the schedule and made her a runner.
Okay.
So was the technician aware that she couldn't work, or was she under the impression that she could because she was allowed to by Banner? Maybe you don't know that, but
she in our communications, which are included in the file here, she was under the impression that she could.
Madam Chair, may I? You know, my philosophical problem with this is that a new law comes out or some new provision comes out where people haven't had a chance to really digest it and understand it. There's all kinds of questions. People who are subject to this new rule haven't had a chance to digest it. And so I'm in favor of some leniency when in a state of emergency, new rules come out or authorizations come out and new programs are put into place like this emergency authorization to work. And so in general, I just want to say I'm in favor of granting some leniency and not necessarily following the grid. The grid is more for clear-cut laws that have been in place and everybody should know them or does know them. And so this doesn't kind of fit under that.
I agree. And if I was given the impression by my employer that I was able to work, that would even add to my confusion. So.
Any further discussion, or do we have a suggestion on a motion here?
I think the employer had some due diligence here, so they would be the permit holder. I think it's very hard when your boss tells you it's okay to work, and you think you've gone through and done everything that you should have done as a technician. It's a statement. So I am with Mo on this Mefford, maybe an advisory letter to the employer because it was something they probably should have. Nobody's perfect. Time of crisis and things are different. That's why this is a different case. So that would be my suggestion.
I think we already did that in the earlier case.
And my suggestion is, and Mo, I'll stop if this is what you were doing, but Ms. Mefford was listening to her boss. She had thought she had applied for the right information. I just think that the permit holder was addressed in this and the permit holder reacted. I think nobody's hurt. I think we move on.
Yeah, I agree with that. That's kind of where I was headed as well. So if you want, I'll make the motion I don't know, what's the right motion, to dismiss, to take no action?
Approve the permit.
Approve the permit. I will make a motion to approve the permit.
Second motion, second. Any further discussion?
May I just interject? I think it's a technician license that's on before you, not a permit.
Yeah.
Yeah, I'm sorry.
Approve the technician license. Thank you, Ms. Hess.
Any further discussion, board members? All those in favor?
Aye.
Aye. Any opposed? Hearing none, motion carries. Dr. Gandhi, Jennifer, can we do item 24? That seems pretty straightforward.
Yes.
Jean, are you speaking? Can't hear you.
Yes, that is something you could do. The underlying matter has been continued, but at least this would be taken care of.
Okay. So
just a quick question. Would Mr. Solari be recused from this as well?
Why would I be recused?
I thought you were recused from the Fusion IV.
No, that was item 4U, Optum Infusion Services.
Oh, I'm sorry. Sorry, just trying to, look out for you.
So item 24 is a discussion and consideration of the Prohoc Vice for Fusion IV Pharmaceuticals. Mr. Hargraves, Ms. Galvin, is this in compliance with what you would need for us to be able to proceed to allow Mr. Mohajerian to be their counsel moving forward?
Yes, I would recommend approval.
Okay. Do I have a motion for approval?
I will make the motion to approve.
Thank you.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
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 Any opposed? Is there any other items we should take today? Looking for direction from staff.
Madam Chair, you could, of course, do my review if you want. I mean, it is 4:10. I don't know how much you guys want to beat me up, how much time is needed for that, but item 31, if the board
26,
wishes.
26 is time sensitive, 27, 28, the rest of the items under 25, 29. I don't know. Board members, how do you feel? Would you like to adjourn for the day or continue on?
I'm in
think we
favor of
should do
continuing.
31.
I'm sorry.
I think we should address 31.
Okay.
Yeah, let's do Cam and then adjourn.
Okay. For the sake of the public, I'll do a brief call to the public, and then we can do item 31, which is the executive director review. For the public's sake, we will not, as Crystal's teeing that up, we won't do any other formal business after that, but we will come back into open session and adjourn after going into the executive session for the purposes of his review. So Crystal, if you can display the call to the public, we'll take that and then we'll move to 31.
Okay, and please keep in mind that there's a 20-second delay before it shows on YouTube.
Thank you. Do we have anyone present on the Zoom that would like to address and call to the public?
I don't think we have anyone.
Okay, and nobody on the other line?
No.
Okay, thank you, Crystal. Again, for the members of the public, we will be going into executive session for the purposes of discussing employment matters for Dr. Gandhi. We will not conduct any business after that today, but we'll come back into closed session, into open session just for the purposes of adjourning, and we will begin tomorrow again at 8:30. Yes, Jane.
When we go into executive session for the purposes of review, there could be action taken in public session regarding that review.
Okay.
I think maybe a representation is there wouldn't be additional board business except as it relates to the review.
Thank you. Thank you for that clarification. I appreciate that. All right. Do we need a motion to go into executive session?
We do a motion executive session for the purpose of reviewing personnel matters and receiving legal advice if necessary.
Thank you.
I'll make the motion.
No.
for executive session.
Okay, and then once we vote, you can do this a couple ways. Cam can come in the beginning, or Cam can come in later. If you want to discuss his review, ask him questions about his performance.
I think let's talk for a few minutes and decide if there's any questions that we have, and then we can bring him in.
Okay, let's see. Cam, should I text you when they're ready?
Yeah, you can let Jennifer know and she can then speak to Crystal or something.
Jennifer Kay should not be in this executive session.
She's not, okay.
I will take minutes.
If it's easier, then we can do it first. That's fine. And then if we need him, we can always call him.
It doesn't matter. I'm just looking for your phone number. All right, so we can go into executive session. So if Crystal can take everyone, just the board members, Seth and myself.
I think we have a motion. Do we have a second? And do we need to vote?
Second.
All right, all those in favor?
Aye.
Aye. Any opposed? Thank you. Looks like it. All right.
Yeah, they're all out of the room.
Thank you, Crystal. All right, so in the matter of the executive director's review and compensation, returning from executive session from our discussion, do I have a motion on how we would like to move forward with this agenda item or motions?
I'm willing to make a motion. In fact, possibly 3 motions.
Okay.
Number 1, I wanted to authorize our chair to discuss the evaluation that we put together with Dr. Gandhi. Do we need them seconded one at a time, or can I just go through all 3 motions?
I would separate them.
Second.
I have a motion and a second. Any discussion? All those in favor?
Aye.
Aye. Any opposed? All right, that motion carries to allow me to discuss the performance review with Dr. Gandhi.
Be sure everyone votes.
Did everyone vote? Do we need to do a roll call?
No, but I just didn't hear everyone.
Okay, all those in favor?
Aye.
Aye. Are we okay, Jean?
Yes.
Mr. Dang, you might be on mute.
Sorry, aye.
All right, okay. Next motion.
I wanted to make a motion to authorize a raise for the executive director in the amount disclosed, in the amount that we discussed in the executive session.
Have a second? I have a motion by Mo and a second by Joe. Any discussion? All those in favor?
Aye.
Any opposed?
Nay.
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 Motion carries.
So 3 nays for the record, I believe.
Yes. Motion carries.
The third is to authorize the executive director to provide spot incentives to his staff in the amount of his discretion.
Do I have a second?
Second.
Do we need to add into the motion if financially feasible within the budget, or is that assumed?
That will play into his discretion.
Okay, thank you. So I have a motion and a second. Any discussion? All those in favor?
Aye.
All those opposed?
Nay.
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 5-3. No, I'm sorry. 6-3. Motion carries. I think that takes us to the end of our business for today. The time is 5:27 p.m. I will make a motion to recess for the day, and we will return at 8:30 tomorrow. Thank you guys for a very productive meeting. I think we got a lot accomplished, and hopefully tomorrow will go very smoothly.
Thank you.
Thank
Bye.
you.
See you tomorrow.
Bye.